Board of Zoning Appeals is now in session for the regularly scheduled meeting of November 21st, 2019. My name is Emily Lamb, and I will be presenting the cases to the board, for their review in today's public hearing. Members of the public at this time, please take a moment to turn off or otherwise silence your cell phones or other devices so the board can hear these cases without interruption. That would be much appreciated. For these public hearings, the board reviews the correspondence submitted in support of and opposition to these cases. The board also reviews correspondence and recommendations from other government agencies in preparation for the hearings. In today's hearing, staff will present the site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, the board will hear those wishing to speak in support of the appeal. If the appeal has opposition, the board will then hear from those parties. After the opposition presents its testimony, the appellant will have a period for rebuttal. According to the BZA rules, the appellant has 5 minutes for presentation if no opposition is present. In contested cases, the BZA rules allow 10 minutes for each side to present testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some portion of the allotted 10 minutes. At the conclusion of the hearing, the board will deliberate and then vote on that case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, Section 1740-180. All section numbers that we refer to today come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The Zoning Code was adopted by the Metro Council and became effective on January 1st, 1998. I will introduce the entire Zoning Code and make it a part of today's record. The Metro Code requires a record of these proceedings. Because BZA meetings are recorded for the Metro Nashville network, it's imperative that anyone addressing the board please come forward to the front table and speak into the microphone. All speakers should identify themselves by name and address and then make the desired presentation. The Metro Code requires 4 members of our 7-member board to establish a quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more members are present, but the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to Chancery or Circuit Court within 60 days of the entry of a BZA order. Additionally, as per the BZA rules, an aggrieved party may file a motion for rehearing by the BZA within 60 days of the original hearing date. After that time elapses, the board's decision becomes final and no further action can be taken. If your appeal is granted, you are required to obtain the permit for which you applied. A permit must be obtained within 2 years for board approval to remain valid. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all cases have been filed in proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. I do have 2 preliminary announcements regarding deferrals and withdrawals. First, case 2019-449 has been deferred to December 5th. And case 2019-457 has been deferred indefinitely. For members of the public, our board utilizes a consent agenda at each of its meetings. One board member reviews the record for each case prior to the hearing and identifies those cases which meet the criteria for the requested action by the appellant. If the reviewing board member determines that testimony in the case would not alter the material facts in any substantial way, the case is recommended to the board for approval. We'll enter into the record those cases that have been so recommended, and if anyone is here in opposition to one of the cases identified for the consent agenda, please raise your hand, make sure I see you. We'll pull the case off of consent agenda and hear it in its regular order. Please note that on any sidewalk case that is placed on the consent agenda, the applicant has agreed to the recommendations made by the planning department. Mr. Chairman, these are the cases that have been recommended for the consent agenda. First, case 2019-401 involving property at 1016C West Grove Avenue. Is there anyone here in opposition to case 2019-401? Seeing none, the next case is 2019-422 involving property at 4730 Lebanon Pike. Is there anyone here in opposition to case 422? Next case, 2019-432, involving property at 1811 Division Street. Is there anyone here in opposition to Case 432? And finally, Case 2019-445, involving property at 4736 Nolensville Pike. Is there anyone here in opposition to Case 445? Seeing none, to review, Mr. Chairman, the cases on the consent agenda are Case 2019-401, 422, 432, and 445. We would solicit a vote at this time.
All right, we have a motion for a consent agenda. Is there a second?
Second.
Any discussion? All in favor, say aye. Any opposed? That passes.
Members of the public, if your case was just approved on consent, you are free to go. Please give our staff until Monday to process all the documentation associated with your appeal, at which point you can come into our office and obtain the permit for which you applied. Mr. Chairman, before we move on to cases to be heard, we would like to take this opportunity to recognize any elected officials who are in attendance. Councilman Nash, would you like to address the board?
Good afternoon. I'm Robert Nash, council person for District 27, and one of the new kids on the block, and wanted to come by and say hello, one, and thank you for all the work you do. I know you don't deal with anything controversial at all. I'm here to
Councilmember, could you turn on your microphone?
I'm sorry?
Yeah, just press the button at the bottom.
Button at the bottom. Oh, yeah, there it is. Okay,
And then-
there we go. Okay. I want to also say thank you, since being new and trying to get my arms around codes and zoning and all of those interesting topics, Ms. Harris has been, Ms. Emily Lamb, rather, has been a great asset, someone you can call on and get some answers, so I wanted to let you know what a good job she does for you. I'm here to speak on the case number 2019-486, the request for a special exemption permit for Cottage Cove Urban Ministries at 4908 Aquatic Drive. I was made aware of this by some community members who held a meeting and were able to question the appellant, Mr. McDonald, and some of his board members. Unfortunately, the community does not support this exemption quite strongly, as you will hear later. And I also attended an open house that was provided by Mr. Brentwood to see, and I can certainly understand their interest in this property. It's obviously cheaper than going commercial to work this their ministry, and the house is it's got some really nice space to do some of the things they want to do. That said, I still question somewhat the location of the building for reasons I'll go into real briefly. But that said, I don't question their mission, their ministry, or their motives. This particular location is 1/2 mile from their front door to the front door of Tusculum School, and this is the primary source of some of the children that Cottage Cove would see as at risk and want to reach out to. I know in their initial letter to you all, they mentioned that they foresaw kids walking. And at the same time, they've also said, we want to start with kind of kindergartners and first graders, get them while they're young. I can say that there's no appropriate place for any first grader or kindergartner to be walking along Whispering Hills and McMurray and down Purnell. So I would ask that you consider as a reasonable condition that this ministry use their bus and pick up these children wherever they may be at Tusculum School or nearby church or daycare, wherever they finally find their clients. That will, number one, reduce the pedestrian traffic and the traffic on that area without individuals coming with their vehicles and like, and then also provide for the safety of children. It just would not work to have kids walking in those areas. Whispering Hills particularly has been chosen by Public Works as one of the low streets that we're going to be some traffic coming on due to the number of accidents, amount of traffic, and speeds and the like. Secondly, we'd also ask that a maximum number of children be present at any given time. If and again, just to kind of keep down some of the noise concerns of the neighbors and help reduce potential traffic to and from this location.
Councilman, do you have a thought on what that maximum should be?
I've suggested 15, and certainly 3, 4, 5, one way or the other. I don't know would make a difference. I will kind of defer to the neighbors and Mr. McDonald and his ministry to maybe work through that. If by chance they should change the focus of their ministry, we would ask that they be asked to come reapply for any further exemption. And then previous problems with parking on that street, there has been a number of no parking signs put along there, and we would ask that Cottage Cove help honor those no parking on the street and help enforce that. That said, I have seen some of the neighbors have people park on the street too, but hopefully we'll all work together and abide by that signage. And then the other thing that I might suggest is that a condition be put on the signage. We would prefer no lighted signs and maybe keep it to a small sign so that it stays compatible with the character of the community. I know given a religious institute, and I know planning has approved this, that you're kind of obligated, so hopefully we can work with some of these conditions.
Is there, have you talked with the ministry, the people at the ministry about this project, and are they aware of the conditions that you are suggesting?
I had a brief conversation with Mr. McDonald at his open house, and where I kind of said I've written a letter to y'all and suggested some of these things, and I believe they're amenable to some of those.
Okay. And so we can talk to the applicant about that. And
Yes.
And, you know, you mentioned in your letter too, you know, the Religious Freedom Acts and other things that, you know, we're bound by. But there also, I think, to me, one of the overwhelming issues that was raised by you and the neighbors was public safety, and then that is something that is excluded from, I mean, if there's an overwhelming public interest that is potentially being harmed by this, that then we certainly could issue requirements, and public safety certainly would, I think, fall into that category. So as are many of the items that you talk about do have a public safety and aspect to it. So we'll definitely talk with the applicant about those specific conditions. And if it does become apparent that there can't be an agreement, then we certainly have the option to defer the case to have additional community meetings with you and other neighbors to try to work out something. And I'll assume that that would be preferable to passing something that isn't as complete as what you've suggested today. Is that a fair assumption?
I think that's fair.
Okay.
Yeah.
I just wanted to, and congratulations on your election, but just wanted to make sure you knew.
Yeah. I think it's in order. I'm not sure yet.
That those are tools. Yeah, exactly. Yeah, be careful what you ask for, right? But
right.
Those are the tools that we have to, in cases like this, that we certainly do have the option to have a continued community conversation through deferral and until we come up with a final answer.
Thank you very much.
Hey, thank you for being here.
Councilor Murphy, I assume you want to speak at the time of your case. I don't see any other council members here. So absent any other announcements, Mr. Chairman, we are ready to proceed with the cases.
All right, first case.
The first item on the docket today, Mr. Chairman, is the item, the matter of whether or not to defer the January 2nd meeting. It's the first meeting in January, and so I think the item on the table is whether you want to move the cases that have been filed for that date to January 16th.
Yeah, there was some discussion about the January meeting being just the day after New Year's, and that there was some issue with this board being able to have a quorum because of holidays and travel. And I don't think I think there were maybe 7 cases. It was a pretty small docket.
There have been nine cases were filed. The filing deadline has passed, so it's a maximum number of 9 cases. The notice letters have not gone out. So if y'all do determine that you want to defer all of those cases to the 16th, no one will have been notified yet.
I don't have an issue with that. Is that a motion to defer those cases to the 16th and a second? Any other comments or discussion? All in favor, say aye. Thanks. That motion passes.
The first case for the board to consider today is case 425. This is involving property at 7721 Whites Creek Pike. Is the applicant here for case 425? Yes. So this is a request for a special exception to use an existing farm as a campsite. Before you is the zoning map showing the property, and the zoning is AR2A. This is aerial photography giving you a sense of the property and surrounding area. This is the proposed site plan for the campsite. And finally, the photograph showing you the current conditions of the property. Is there anyone here in opposition to case 425? Seeing none, the appellant will have 5 minutes to make your presentation. Please be sure to identify yourself by name and address.
My name is Lori Burkhead, and I own the property there at 7721 Whites Creek Pike. It's a 95-acre farm. The mission of the farm is to grow food for area food banks. We've been doing that since 2011. We work in conjunction with Second Harvest. It's their farm to families program, so we've been doing that for some time. We have children that come in the summer, teenage kids that come to learn about farming, explore more about their faith, and help with the mission of growing food for others. Some of the kids approached me, and they're adults, about having a small campground so that when they come, maybe once a year, they could pitch tents, maybe have a little cabin. And so that's kind of where this idea started. And that's predominantly what it would be for, is for the kids that come and want to learn a little bit more, connect to nature, to the idea of serving others. And so that's what it's about. I really don't want anything very big. As you can see from the drawings, that's our master plan, and that would not even happen right away. We're looking at a few just platforms for tent camping, and possibly build a couple of those little A-frame cabins. So there would be the roadways that you see on those maps are all existing. They've been on the farm for I don't even know how long, before 1950 for sure. So there would be no electric or water down to where the campsites are. It's primitive camping. So it's pretty simple little project.
Great. And then I think there was the planning department staff had recommended approval of this project. I think there was one person that had sent a letter, a general letter of opposition saying that they didn't want that. Did you have any other feedback? Did you have a community meeting?
Well, I had a community meeting, and I had 6 neighbors. Of course, most of my neighbors are have property, but they don't live there. They may have land there, you know. But everyone that was there, I had one gentleman, Mr. Spain, asked some questions like, well, how are you going to keep the riffraff out, you know? But when he left, he was very cordial. He said, I'm not going to oppose this. I think what you do here is good. I have neighbors that still don't exactly know what we do on the farm, but most people in the Joelton community do, and they're very, very supportive of what we do. And everyone, as a matter of fact, I've got 3 letters. They were emailed to me, but I have copies of them, of people who wrote saying, we love what you're doing. We're so happy. This is a great idea for the community. And one man that came back and said, I'd like to help you. Could I, if you get ready to build these cabins, can I come when you have the kids here? And so I've had nothing but but wonderful support, people saying they want to actually come and help if there is any help. Of course, to build a couple of tent platforms and some A-frames, not a lot of going on there, but I appreciated the support of the community.
Right, and we don't have those letters in our packet, so if you wanted to submit those, you can give those to Jessica at the end of the
Okay.
table, and she can put those as part of the public record if you'd like to
Yep, I've got 'em
just
right
have those
here.
included.
Okay. If you want to read it, it was such a sweet letter.
So did you have anything else that you'd like to add, or?
Not really. I mean, after this, I don't know what, these are pretty basic. I didn't know if I need to go on then for a permit for a tent platform, or that, I wasn't sure what happens next.
Well, I don't know that I could tell you that either, but that, I'm sure, I would consult with
Got
the
it.
code staff before you build anything, and then they can tell you if you need a permit or not. But like I said, our job today is just to allow you the special exception use or not, and
Yes.
and then you'll have to work with the other city folks to
Sure,
take it from
sure.
there.
I understand. And I appreciate you hearing this today. I know you'll have a busy agenda.
Are there any questions for the applicant?
Public Works had no issues with it, provided that adequate parking was provided. Have you taken care of that?
Well, yeah, we'd have adequate parking. I mean, it's a 100-acre farm, and we've had, I had my nephew's wedding there, actually, so I know we can park 50 or 60 cars. But this is the maximum amount of number of people that would be back there, even if we built it all out this summer, would be 30, and that would be the max of maybe 15 cars. It's like 2 people per little cabin or a campsite, and I really don't want it any bigger than that. So I'm not looking at something that would require a lot of parking.
Okay, so
Yeah.
that's not an issue, is what?
Yeah, I don't think it'd be an issue at all.
Thank you.
Any other questions? Anything else that you'd like to add?
I don't think so.
All right, we will close the public hearing and discuss. Thoughts?
I think she sufficiently established grounds for a special exception. The opposition, I think, was more general, and she has addressed my concerns that I might have about vandalism and taking away from the peace and quiet of the neighborhood because it's relatively small encroachment on a 100-acre farm. So
Motion?
I make a motion that we grant the special exception with the recommendation from planning that there is sufficient parking.
Okay.
Second.
Have a motion, have a second. Any discussion? All in favor, say aye. Any opposed? That passes. Good luck.
All right, thank you.
All right,
Next case, 2019-439. Is the applicant here on case 2019-439? Mr. Chairman, this case was on the last meeting's agenda. The applicant did not show, and so the board deferred it to today. It appears he's not here as well, or today either.
All right, so this is the second time that this applicant has not shown, and so because of that, I will move that we deny the request. Have a motion, have a second. Any discussion? All in favor, say aye. Any opposed? That motion passes.
The next case to consider is case 2019-479. This is involving property at 199B Bowling Avenue. This is an item A appeal challenging the zoning administrator's determination that a fence constructed at this property meets the legal requirements for fencing. Before you is the zoning of the map showing the zoning of the property is R8. This is the area photography giving you a sense of the property and surrounding area. And finally, the current conditions of the property as well as up and down the street. I will note that these pictures were taken a few days ago, and my understanding is that the fence has changed since that time. The opposition to this appeal has provided more pictures, so I've got those, and I will bring those up when he's ready to speak.
And just so, just a note to the crowd, I think that I think there are people here that, I'm just going to say oppose the fence. Is that, raise your hand if you're here. All right. And so it becomes a little bit, when we talk about support and opposition, in an item A case, it becomes a little bit confusing sometimes because it's not a typical variance case where some people want something and some people don't. And it's kind of flip-flop because supporters of this case support the zoning administrator. It's the other way. Supporters of the case support overturning the zoning administrator. Opponents of the case support the decision of the zoning administrator. So you can see it's confusing even for me. But just so if it's your first time here, an item A case by definition challenges the zoning administrator's determination. So the zoning staff has determined that the fence is a legal fence, and the appellants here are here to tell us why the zoning administrator and or his staff erred. And that's really the issue, as how the zoning administrator either erred or did not err in this determination. So I know a lot of times these cases get clouded with other issues and that type of thing, but what we're here today to figure out is did the zoning administrator err or not? So just so everybody's clear on the nature of the case. And so the way this usually works is that we have the zoning administrator tell us how we got here, and then we hear from the folks who think that the zoning administrator was wrong, and then we hear from the folks that think the zoning administrator was right. And at any time, council members and or the zoning administrator or us as a board can ask questions of the parties involved. So just want to make sure everybody understood that. So I guess we'll start. Did you've presented as far as you're going to present, and then
I've got the presentation.
Okay, then let's hear from the zoning administrator.
The final caveat to the procedural point, Mr. Chairman, of course, is that the appellants, those who oppose the decision having been made by the zoning administrator, will have some opportunity for rebuttal after the presentation by their opponents if they choose to leave sometime for that rebuttal. And if they choose not to, that's okay. It's their prerogative. To the question, how did we reach this decision? The fence located on the property at 199, presently addressed as 199 Bowling Avenue, actually sits at that very acute triangle that you see on this aerial photograph, right where Whitland and Bowling intersect. There are three components that have been brought into question as to whether or not the fence that exists is in fact in compliance with the Metro Code, citing the section of law that's primarily applicable here, at least the first part of it, and that's under 17.12.040, section D as in dog. I got that part right? And on to 26. It has to do with screening walls and fences. This is a section, broadly, the section that talks about that which is permitted to be built within setbacks. The section involving fences and or screening walls has three parts, A, B, and C, that outline some of the particulars. The fence that exists as of this morning at 9 a.m., when I went out for the second time this week to walk around and look at it, covers nearly the length, not nearly, I shouldn't say the full length, but much of the length of Whitland, starting at the intersection of Whitland and Bowling, going roughly southwest toward the existing home. This aerial photograph is a bit dated, of course, but nevertheless, the street continues down that walkway with a retaining wall in place and a fence sitting directly on top of the retaining wall, with a sidewalk right up against the retaining wall on Whitland. Going down Bowling, slightly there to, I guess, going south, almost due south, alongside Elmington Park there toward Weston Middle, the fence sits off the property line on the other side or the inside of the sidewalk at 6 feet in height. There's no retaining wall on that portion of the property, the grade only changing downward as you go westward toward Whitland. The three key questions are these. One, is the fence too tall on Whitland? Because the fence is constructed on top of a retaining wall, the effect for a pedestrian walking down the sidewalk on Whitland is to look up and see a good 10, 11 perhaps feet. I wasn't tall enough or athletic enough to reach the top of that to give a good measurement, but what we'll call 10, maybe even 11 feet in height at its highest point. Again, from the pedestrian walking on the sidewalk looking up. That is with the fence, 6 feet, being constructed on top of the retaining wall. Second, the second question has to do with what we refer to as the visibility triangle. That's a separate piece of law that governs that, having to do with partially pedestrian safety, but even more so for automobile safety as they approach the stop sign intersection there at Whitland and Bowling. There has to be a distance from the corner, that tiny acute angle in the corner of this triangle, back down Whitland 35 feet back down bowling 35 feet, and the triangle created by that measurement must be free from any obstruction. The ones we typically look for are, in fact, fences or screening walls or anything like that. However, newly planted shrubbery or trees can also be part of the equation if, in fact, they are newly planted. It's a separate section of law that governs that. I believe that's 172180. I want to make sure I've got the right reference in the record. That's 172180, having to do with visibility. Section A talks about those 35-foot lines that have to be preserved and the visibility triangle maintained for the safety at the intersection. The third and final piece of this that's in question with regard to the propriety or legal nature of the fence has to do with the setback of the fence off of Bowling. As referenced, the same 6-foot fence exists on Bowling Avenue, as is the case on top of the retaining wall at Whitland. However, because there's no retaining wall, it sits flush to the ground, and a pedestrian on the sidewalk at Bowling sees what appears to be, and in fact is, a 6-foot fence right there in the yard. The question is with regard to setback. A 10-foot setback is required for a fence off the property line if the fence is going to be 6 feet tall. A property owner is allowed to put a fence within the front setback, even all the way out to the edge of their property, if in fact that fence is no more than 30 inches or 2.5 feet in height. Think the overly stereotypical little picket fence in the front yard, if you will, for a visual effect. However, many folks who choose to do a front screening or privacy fence choose to go ahead and move that 10 feet off of the property line, build up to 6 feet, but no more, and that's what's been the case here. I mentioned that we, meaning multiple code staff members and even the director of the mapping division of planning, went out and did a second walkthrough this week, earlier this morning during the 9 o'clock hour. Here's what our measurements reveal. The 6-foot privacy fence on the Whitland side does sit on top of the retaining wall. Combined, if you measure from at what point you have retaining wall, you do not have screening wall, meaning the portion of a wall that holds in dirt, we do not treat the same as a privacy fence or screening wall. Only when the wall or fence goes beyond ground, grade, dirt, do we begin counting the maximum height. It's less than 8 feet at that location on the back of the property, which is Whitland. The front of the property, having been determined as Bowling upon construction of the house that faces to Bowling, is addressed to Bowling, which then by necessity and frankly default logic makes Whitland the rear property line. Hence, the 6-foot fence on top of the retaining wall, so long as at no point the combination of wall, which is made of concrete block in this instance, plus the 6-foot wood opaque fence, as long as that never exceeds 8 feet, then it's legal. And that appears to be completely legal at this point based upon the presence of the screening wall. Part number 2, the visibility triangle. We did our measurements with a tape measure, dropped from the apex of the triangle there, back down Whitland and measured 36 feet. Ms. Lamb, if I could ask you to click over to the first of the 2 site visit, or I guess the second of the same photos. The photograph seen to the right here shows that intersection. If you look almost perfectly in line with the backside of this stop sign, you'll see where the last panel of wood fencing is in place. Beyond that, coming closer to the intersection, you see 2 more posts where panels had been in place previously. This is obviously a fence in some phase of construction, reconstruction, or deconstruction. The prefix on that word doesn't matter as much. The state of the project at the moment is such that the first portion of upright fencing, not the posts, but the fencing, stand 36 feet away going down Whitland. Looking down Bowling, the first panels of fence, not posts, but panels, are a little over 50 feet away, closer to 51 feet, in fact, based upon our measurements. In that regard, they have accurately preserved, in accordance with 172180A, the 35-foot line coming off the intersection from the street in accordance with the visibility triangle requirements. Now, of note, if for some reason they chose to put those panels back in place, they will be in violation of 172180. If, however, they merely enclose by going a straight line from point A to point B with the 2 ends of fence panels there, again, removing consideration of the remaining posts where they've just taken out these panels, then they'll be in compliance with the law in terms of the specifics of 172180. And that's up to the builder at the end of the day. The third and final component of the analysis has to do with the frontage on Bowling, the front side of the property. Here it's the setback question. Is the fence that exists 6 feet or less? Yes. Is the fence 10 feet set back from the property line. Here, the longstanding practice of the Codes Department, dating back not only through my time as zoning administrator, but with my predecessor while he was zoning administrator and his predecessor while he was zoning administrator, thus covering neatly the last 60 years of Nashville's history, has been to say, measure from the back of the curb to get your 10 feet here. If you've got a survey that specifically shows something different than that as the appropriate measurement for end of property line, beginning of right-of-way line, then go with that. Absent that, it's a good go-by for the Codes Department and their inspectors in the field to go out and determine from rear of curb, interior, that's how you can find your 10 feet. Having gone out again this morning with my colleagues during the 9 o'clock hour to make exactly that measurement from back of curb as shown in the upper left-hand photo. No, sorry. Do we have a photo of the bowling sign, Ms. Lamb? Not a good photo. Lord knows there's plenty of photos being circulated. I'll encourage the board members to take advantage of any of the dozens of shots of this fence to see the bowling side. It's just right at 12 feet from back of curb, across the planter strip, across the sidewalk, over a very, very small patch of monkey grass that's planted at that location to the fence, thus beyond the 10 feet required in that instance. So by way of recap, we have to ask the question, is the fence in compliance with these three separate components that are in question? One, the height along the rear, along Whitland, yes, because the retaining wall does not count as fence or screening wall. The fence screening wall is allowed to be no more than 8 feet and stands at 6 feet in some portions on top of some of the concrete block used for the retaining wall, but even then below the 8-foot measurement. Secondly, have they preserved the appropriate visibility triangle in accordance with 1720-180A? Yes, as long as they do not enclose what's shown posted from the prior version of the fence, but instead merely enclose that which is remaining from the existing panels. At 36 feet and 51 feet respectively, they'll be in compliance with the law. Finally, with regard to the setback along Bowling, yes, they're more than 10 feet off of the back of curb measurement, right around 12 feet, in fact, based upon our measurements, and thus in compliance by keeping it at 6 feet or less and more than 10 feet from the front or street setback. That's the analysis. I'm happy to answer questions for the board members. I know that very capable attorneys and community members are eager to speak with you about their view of the matter. One caveat that I will give at the end of this is very practical in nature. None of my legal analysis should be misinterpreted as, and boy howdy, I think it's a great fence. Gee whiz, I love 10, 11-foot fences through residential neighborhoods. Because that is the effect when you walk down Whitland, is to see what looks, feels, and operates like a 10 or 11-foot fence while walking your dog in a long shadow or maybe going for your morning run in the same long shadow. However, in the same way that the Codes Department, and more specifically the zoning code, does not regulate ugly or regulate my particular taste or preference, we just have to look to what's allowed. We think we've correctly identified what is allowed for each of the three components of this analysis of the fence that's been constructed or is being constructed. So while I'm happy to answer questions, I think that pretty thoroughly summarizes how we got where we are.
Thank you. And
So, you have one.
well, and I understand. I mean, I appreciate that, and I have my experience on 7 years on this board has shown is experience that the Codes staff is very works very hard to be consistent in how they apply things, and I think that the rule of thumb that you talk about was certainly makes sense. I mean, in terms of how, especially since fences don't require permits, and if they don't require permits, they don't require surveys, and that you have to have some benchmark if you don't have those tools. And but I guess the question that I have is, because you'd said a couple times 10 feet off the property line, and then we're just approximating that with the curb because of the absence of all these other things. If the applicant had provided a survey that clearly demarked the property line, would it have a different interpretation because you knew the property line was, say, on the other, say the fence is actually on the property line? Would that have, knowing that that is where the property line actually is from a survey, would that change what type of fence they could build and where?
Sure, a stamp survey would absolutely be part of our consideration. We'd reanalyze the question based upon what we learned from a stamp survey of that sort.
Okay, and so absence of a stamp survey, the historic rule of thumb has been to go from the curb as an approximation, because that's, and again, I don't question the reasonableness of that. I don't know how else you would do it. I think it does sound perfectly reasonable to me. But it is because of the general absence of a stamp survey on a fence because fences don't require permits or that type of thing.
And the piece that goes with that, Mr. Chairman, and the more, I shouldn't say older, more experienced land use professionals than me would note that NES is particularly meticulous about putting their poles right at the edge or as close as they can in a planter strip to the line of demarcation between public right-of-way and property line for the private property owner. As you'll notice in the photograph shown here, you see power poles planted as close, as far to the edge of the planter strip, right out to that backup curb as can be without being literally in the street or in the pavement. Although that's hardly the equivalent of a stamped survey, it is, again, for builders in the field, a generally good practice to make sure, okay, if I'm getting closer than NES got, then I'm probably in the wrong. And again, that's what land use professionals have told us for years is an easy jumping off point in the field absent any other specific instruction, or like you've indicated, a stamped survey that gives more specific guidance.
And I guess the only other question, and again, to me, these are the types of questions that we're going to ultimately have to think about, and on this board, which, again, I've been on this board a long time, and these are new questions. We've had several fence cases, but none exactly like this. They're all slightly different. But the rear setback, I mean, the fence is in a section of this property that has a front setback and a rear setback with no side setback on that end, and so it's been determined that the Whitland side is a rear setback, and I guess to me the question is, when the code says within 10 feet of a street's right-of-way, it sounds like the codes department has always interpreted it as a front and a back, and if you're a back, then that street isn't considered. But it sounds like that's how the practice has been, and the question that may be raised or may not be raised is that correct?
That has been the practice. The analysis is don't stop reading at Part A. A, B, and C are all equally applicable here under subsection 26 involving screening walls and fences. A does speak, as you said, of within 10 feet of a street right-of-way, which at least opens the consideration of, well, do we mean every single street, regardless of front or back? Reading on to B, which must be read along with C in conjunction with A, B talks about 6 feet within the remainder of the required front setback. The very word remainder harkens back to Section A and suggests that the two work together. So talking about the remainder of the front required setback seems to bridge those two a little bit and suggests it's not just any street right-of-way. After all, there are occasionally projects, as we all know, that take up an entire city block fronting 4 streets on 4 sides. The idea is not to push all of them back necessarily in that regard. Here, because B can be read in conjunction with A, I think the basis for my predecessor's consideration, and one that I join in saying that I think it's the right way to read it, is that 6 feet in height within the remainder of the required front setback in Section B works hand in hand with Section A, thus allowing the 6 feet in height in the front. To the rear, Section C has its own language saying 8 feet in height within the required side or rear setback. Okay. Doesn't say where within that setback. A greater delineation or specifying sentence might say, but if you're on a street, you don't get to be that close. Well, doesn't it say that in A, John? Yes, it says something like that on A with regard to the front setback as clarified in B, but when reading all 3 together, in context, we think that's the way that it unfolds in the field, and particularly on this particular property, 199, 197, if it's ever built out, bowling.
Okay. Any other questions for the zoning administrator at this point? Thank you. I think maybe you answered all of my questions, and we don't have to come back to you. All right, we'll hear from the applicant.
Thank you. I'm Councilwoman Kathleen Murphy, 231 Orlando Avenue, and I am the applicant in this case. And today you're going to hear for myself as the applicant, from me, from David Kleinfelter, who has been retained by one of the neighbors, and from the neighborhood president, Cyril Stewart, as well. And I'd like to save 2 minutes for rebuttal. I also would like to say that was as clear as mud probably to y'all like it was to us, but this is actually the first time that I or my constituents have heard the justification of why the zoning code is allowing, or the zoning administrator is allowing this fence. We've asked for it numerous times, as I'll get into. So today I'm challenging this fence because it clearly, if you read the code, it is out of compliance with the code regulations. It is nice to hear that we have some rules of thumb, but that is why we have the zoning code. The zoning code does not say you measure from what might be the right-of-way. You measure from where the right-of-way ends and where the property line begins. And I think if they had pulled the permit that has been, it's expired now for the second house to be built here, it clearly shows on that site plan where the rear setback is to build that house. And so it clearly shows that the right-of-way is where is the back of this sidewalk. And I think we'll address a little bit more of that in time. So I've passed around to y'all. You can see the pictures from over the last 10 years of both angles, thank goodness for Google Earth. So you can see clearly both sides. And what I'll get into, and I think others will as well, is that this, what they are now referring to as a retaining wall, historically it is a fence. It has been a fence. And so I guess at this point now, y'all might have to decide at what point does a fence change into a retaining wall? Is it because the property owner has changed the grade and the topography of that lot, creating this a retaining wall? Does my height change on my driver's license because I am wearing heels, or is it how I am actually measured from the ground? So going back over the course of this summer, myself and then our council attorney, Mike Jameson, who also lives in this neighborhood, on my behalf, started questioning the codes department, along with many neighbors turning this into Hub Nashville, wondering how this fence is being allowed. It was finally inspected in June. There were 4 violations for this very fence marked in June. They were given a letter saying that they were out of compliance with the law, with the code, in 4 ways. Surprisingly, it was re-inspected June 15th and found that those violations had been cleared up. Nothing had changed about the fence that you see now and the fence that was inspected and found in violation. Actually, what you find different between the pictures here and the pictures I took on the 18th is that they have taken down what Public Works told them for that visibility triangle to take down several weeks, going off memory, at least a month ago, I think. They've been told to take that down. It was just taken down conveniently before the zoning administrator went out and measured today. So again, we were not told. All we were told is we do have one email that says that there's a retaining wall and there's a fence, and that's how it's been found in compliance. Again, we'll get back to when does a retaining wall change from being a fence, because it's clearly the concrete wall does not hold back soil the entire way down the Whitland Avenue. So as you can see from the pictures that I submitted you, that on the bowling block face, that the fence is within 10 feet of the right-of-way. It is within that front setback. It is clear, it is obvious, and the fence on bowling is not in compliance with the code. I've tried to do some creative ways to figure out how it could be in compliance, but when you know the property line is the back of that sidewalk, that's where you measure from. So it's clearly out of compliance with the code there. The fence that is on the Whitland side is also within 10 feet of the street right-of-way. It's an opaque fence, and it also is over 2.5 feet in height. Again, the code, as the zoning administrator has acknowledged, 1712-040E26A, it cannot be that close to the right-of-way if it is over 2.5 feet. So I think the pictures demonstrate this pretty clearly. I think that it was a pretty complicated explanation, but at the end of the day, if it's near the right-of-way, next to the right-of-way, or in that front setback, it simply cannot be this tall. Secondly, this is not a retaining wall. It has become a retaining wall by the property owner. And you can see that in the one that's not stapled because I printed it late. This is where it was in progress to be more into a retaining wall. But again, historically going back to 2009, it has not been. So I'm asking you to agree with my constituents and I today that this fence along Bowling is out of compliance with subsection A and B due to the fence height restrictions within 10 feet of the right-of-way and within the front setback. then the fence facing Whitland is in violation of A and C of that subsection due to the restrictions on the height, again, within the side setback and the rear setback. I do also want to make clear, as I join John Michael in saying that I can't take issue with the aesthetics. That is not what we're talking about here at all. We're simply talking about the code says one thing, and it is clearly being interpreted as long-standing practice, kind of a rule of thumb. When the code clearly guides us to how this should be measured, we should be following the code. So with that, finding this fence in violation of the code and requiring the fence to come into compliance, it does not take away from the property owner's ability to construct a fence in compliance. As you can see, at least going back 10 years and further in my memory, there has been a fence here. I think a shorter fence or even a fence that is compliant as it has been in the past still affords that property owner the privacy that can be expected in a historic urban neighborhood setting like this. So I'm going to let the others speak, and then I am happy to answer any questions.
All right, I am David Kleinfelter, representing Tom and Kathy Pennington. It's going to be hard to address the mental gymnastics that you just heard in the time that we have allotted. Like the Councilwoman said, we ask and ask and ask, and we're never told about these unique interpretations. I understand rules of thumb. Never before have I heard that the right-of-way ends at the curb. Sidewalk is clearly within the right-of-way. The code clearly says 10 feet from the right-of-way. To say that the property line is the back of curb means that homeowners can build 30-inch fences, if you read that code, within that whole sidewalk area. Because it says, within that 10 feet, it has to be no more than 30 feet tall. Within the 10 feet is measured from the property line at the street right-of-way setback. There is no question that the back of that sidewalk is the street right-of-way the street right-of-way. You have to go 10 feet back from that. It's just scary to me that, frankly, it's being said that the right-of-way ends at the curb, because clearly it doesn't. I hadn't expected I was going to even have to talk about bowling, because I couldn't have even imagined, as the Councilwoman said, any possible justification. It's on the property line. It's higher than 30 inches. It's in violation. The code is abundantly clear.
So I guess the question is, how do you know it's on the property line?
Except in extraordinarily rare circumstances, your sidewalks are within the property way, within the right-of-way.
Also, from code zone documents that I pulled from e-permits of the site plan for this house, and where it says where the rear setback is of where they're going to build the house, the right-of-way is marked on there. The property line is marked on there. If we're going to start measuring the back of the curb for setbacks, y'all know how many setback cases I think I've been here on an item A to determine the setback as well, right? Contextual setback. Can you imagine if we start measuring that 10 feet in? We're going to have houses so far out of compliance if we just start using this new standard that we've heard today. That blows my mind that is where we're going to start measuring. Is it just for fences, or are we measuring that for where people are going to build houses too? So I'm sorry, got a little tangent there.
What you're saying is there's no differentiation there's no such thing as a sidewalk right-of-way. The sidewalk is included within the street right-of-way.
There's a right-of-way and there's a right-of-way. Either the property line starts where the property line starts, or I guess maybe we need to reevaluate everybody's property and everybody gets an extra 10 feet that we could start taxing. I guess that could start.
It's clearly the right-of-way is the property line. If one were to build something, a gazebo in the sidewalk, there would be a problem with that. The right-of-way is right-of-way. There is no distinction.
I've got you there, but the code says street right-of-way. I've never heard of a sidewalk right-of-way, so
there is no distinction.
I'm assuming
street right-of-way is a redundant way of saying right-of-way.
Right.
So your position is the street right-of-way includes all the way up to the sidewalk.
It is the street right-of-way is dedicated by plats as the right-of-way. You put within it the things that the public is determined to need by planning.
There's nothing in the code that defines a sidewalk right-of-way.
No,
as I understand. Okay.
No, and if you look at this is a new building, a new house that's on this lot, so there was a There was a survey done for that, so the builder had that.
Excuse me, just identify yourself and address before you.
I'm Cyril Stewart. I'm the president of the Neighborhood Association. I'm an architect that's practiced my entire 40-year career here in Nashville. And all those 40 years, have never once heard the interpretation of the street curb being the right-of-way. It would have changed a lot of projects, and that precedent could really be dangerous moving forward. If you walk along the street, if you look at any of the surveys, there are pins marked as well as the lot line is shown as it's described in the codes as the back of the sidewalk, as the edge.
I'm going to interrupt because I want to make sure before we get done, I can address Whitland really fast. The code says, measured from finished grade level on the side of the wall or fence with the greatest vertical exposure. That means that you don't get to accept out a retaining wall, because when you look at a fence, if it's on a retaining wall, the vertical exposure is here at the sidewalk. The greatest vertical exposure, that language, which has to be given meaning, as our lawyers on the board know, must mean only that you measure down to the sidewalk. Yes, if they've piled dirt up. And it equally would mean, under the current interpretation, you can go 16 feet high, which
I've got a question about that. When I go down Music Row most days home, and there's the old, I think it's Sony Music, or Vanderbilt owns it now. It used to be a convent, that big giant building that has a really tall retaining wall on one side. It's got to be over 10 feet, maybe 15 feet. And it's clearly holding up dirt in that building. So are you saying that they shouldn't be allowed to have a fence?
it sounds like they have
I don't think we should, I mean, honestly, that topography and that property is completely different from this one.
Well, that's what I was going to say. Yes, they should.
But it sounds like that the argument is, if the retaining wall should always count, then you have a 10-foot retaining wall with no fence, and that becomes a safety hazard. So, I mean, at what point do you?
It's a variance.
Mr. Chairman, if I could, Jamie Holland on behalf of Rick French. My address is 1006 Fallon Street. But the greatest vertical exposure in 1712-040E26, it tells you right where it is. It says wall or fence. It doesn't say, hey, up to a retaining wall, up to a fence. It says wall or fence and the greatest vertical exposure.
I would just.
So your position is that anything that, let's say there was a 6-foot retaining wall there because there was 6 feet of dirt behind it, and I felt like our codes would require a 40-inch, or basically if I went over the limit in order to create a fence just for pure safety, so no one's going to fall over it, that would require a variance rather than, and the hardship would be, hey, I've got so much dirt.
If your lot.
And your topography is such that you have to have that wall to keep your.
All right, so
And this is not the topography, as you can see in the picture. This is, if I mean, how can you call it a retaining wall if it's only holding dirt back partial, like the entire concrete portion of the picture in front of you is not a retaining wall. And again, can you just call it a retaining wall because you've shoved dirt up against it?
I think
I mean, it has been the topography issue was created by the property
So
owner.
the original topography did not require a retaining wall, is that what I understand?
Correct.
So your position is because of the change in the topography, that necessitated the retaining wall?
That's correct.
Well, we would assume, right.
And I think in your other case with the Sony building, some of those were precedent to the code, but today for that building to be done, you could put the retaining wall in, but it would have to have a reasonable setback from the property line.
If I may, the last thing, because I'm sure we're around 10 minutes are over.
Well, our question, luckily for you, our questions don't count, and then the board certainly has the option to consider.
It does say measure from natural grade, which by definition, again, would mean not where you've shoved dirt in. It's where the dirt was as a natural. So the natural grade here, as Mr. Stewart, who lives on the street, said, was much lower and has been backfilled since then to be a non-natural grade. I mean, again, you have two things here. Greatest vertical exposure has to mean, it can mean nothing else than if there's dirt on one side, because that's how you have separate vertical exposures. One vertical exposure, one vertical exposure. And so that's part of it. And the other part is natural grade. If that yard's natural grade, maybe let's say you had a bluff, not a retaining wall, but a bluff, the natural grade was up there, then you could still do it. You can do it 8 feet from that. And again, I do understand we're retaining, I even think, frankly, if it's a true, I don't know that the debate is important as to whether it is or isn't a retaining wall, because as Mr. Holland said, it's a wall, and it counts there, that's when you come in for variance, if you have a topographic unique condition and where it's needed.
And one last thing before our time is out, is that if we are starting to measure the right-of-way being at the back of the curb, that's where the right-of-way stops, then what's going to stop people from them fencing in? If they can have their fence within this area, then why wouldn't people just start fencing in our public sidewalks and saying, oh, no, that's my private property now? I think this rule of thumb needs to be overturned today. If that is what's been going on, we've got to change that.
Well, and again, I'll comment on that in just a second. I have one more question for the third. Let's see. We heard from the code staff that, when they interpret 12.040.E.26, I think it's C, which is 8 feet in height within the required setback, required side or rear setback. They're saying that allows an 8-foot rear 8-foot fence at the rear of the property, and that it is not meant to be viewed as, the same in the same way that A says with a street right-of-way. So, are you arguing that any street?
I was going to, until we had a lot of new things we had to address, because I do think that's what the code says.
I'm asking you that question.
Yes.
I'm asking you to make that argument so it doesn't count against your time.
I
don't hear what you have
believe
to say about it.
the code is clear, and Mr. Michael pointed out where B refers to the remainder of the front setback. That's because in the front, you have been told that your fence has to be back 10 feet, and then after that, it can be within the remainder 6 feet. And on the side setback, there can be instances, when you're sitting drafting this code, there can be instances with a rear setback where there is no street, obviously. So where there is no street, there would be no purpose in using the word remainder, so the drafters just left it out there, but that doesn't mean that A doesn't apply. I think that you're right about how the two work there, but on A, this is a rear setback that happens to be on a street. So there's no reason if you're to discount A. It doesn't say notwithstanding paragraph A. It doesn't say anything like that. So you have to give language to all of them. I will admit that I think side yard fences have typically been done at 8 feet all over town. I don't think the code allows it. The code clearly says within 10 feet of a street setback or street right-of-way, which is the right-of-way, it has to be no more than 30 inches.
Okay. And I think the other thing to address that question is that there are a number of people in this neighborhood that have 8-foot rear fences for privacy and some side fences for privacy, and there is no issue with that whatsoever. However, the code not only has its text, but it also has drawings, and I'll submit this. And the drawings are there for explanation, and it shows that when you have two streets, then there is to be a lot line setback from both of those streets. The effect of what's there now is not just an 8-foot privacy fence up against, one of the most beautiful streets in the city, but an 11-foot fence right up there on the property line on the sidewalk. So we argue that it should apply to the setback as well.
And if it's permitted, it would be allowed to go up to 16 under that interpretation.
All right. I'm going to ask if the board has questions. No, the board may have some more questions, and then I'll ask the board if they see fit to add some time to both sides so that you can have an opportunity for rebuttal after the next group. Are there any additional questions for the applicants? Does anybody have any objection to adding 3 minutes to each side? All right, so you'll have 3 minutes for rebuttal when you come back. All right, we will hear from the folks who support the zoning administrator's decision. Sir, if you could press the button, turn the mic on, again, state your name and address.
My name is Winston Evans, Jones, and Reynolds, 401 Commerce Street, Suite 710. I represent the property owner, Ms. Linda Norman. Seated beside me is, and Ms. Norman's here, and seated beside me is Mr. Victor Becerra, who is the the contractor. And first of all, I've been by that property since I was a kid, but I've never noticed what the fence or any of it. I've been oblivious to it, but I'm told by Mr. Becerra and Ms. Norman that we did not change the topography. That's point one. Point two, there are some pretty basic principles of law here we're all familiar with, but they bear repeating. What we've listened to for the last 15 minutes or so is a discussion about what could be at most described in favor of the protestant, I should say, the applicant here, is a debate about an ambiguity. And we all know that the zoning statutes must be strictly construed in favor of the property owner. Ambiguities are always construed in favor of the property owner, and that's because zoning regulations are in derogation of property rights.
And
So
what was the ambiguity?
well, we're sitting here debating about above, number one, where's the street line? Where's the street right or where's the property line? And, I could make the case that, yeah, the property line stops at the curb, number one, and number two, they say, well, how do you get the sidewalk? Well, the sidewalk's there for a public easement for a right-of-way, but whether it's prescriptive easement or whether it's by ordinance, I don't know, but that's the point.
But
Sure, but how could you make the case that the property line stops at you're talking about the road curb?
Yes, sir.
Tell me about that, because I'm not.
Well, there's been no.
You have a sidewalk right away, it seems to me, right through there, and that's the argument they're making.
My argument is, if we own the property, how can a sidewalk be on it? Simple, it's an easement, it's a public easement for a public use, just like you have an easement down the side of your property for a public utility.
So
the utility doesn't own it, but they've got an easement. My client owns to the curb.
Sure, I'm with you on that, but isn't the easement a right-of-way, Mr. Evans?
I don't think so. It's not a street right-of-way.
Are you claiming that this property does have an easement with the city for that land? And, I mean,
I don't have any knowledge one way or the other.
right, so
This point is just brought up, and I'm trying to respond to the speculation that was made by the appellant here.
Well, and I think that when I ask, how do you know, because I do think it's important, and I think it's I don't have an issue with the rule of thumb till proven otherwise, but they were saying it was obvious that it's, by looking at it, that it's proven otherwise. And I said, well, I don't know that that's true. I didn't say that. I said, how do you know? And the applicant said, well, when this property owner submitted plans to codes to build, I don't know if they're going to still build two houses on the property or not, but the plan shows two houses, and it shows a property line, and it shows a setback line that's curved with Whitland, and the second house zigzags just like that so that it never touches, goes on the other side of the setback line. That's what the first group said was proof that this property does not own the sidewalk and the strip of land. And that seems to make sense to me, that that the property doesn't own the strip of land and the sidewalk. That the property line, or otherwise you wouldn't design a house that looks like that to be right on a setback line that's based on the edge of the sidewalk. So it seems like also the ambiguity. I guess my question is, are you arguing, do you have a different point of view that a 6-foot fence isn't allowed at the property line in the front of the yard, or let's say within 10 feet of the street setback?
My view is exactly what the zoning administrator said. And our view is that the property line is at the curb absent evidence to the contrary.
And are you saying that the site plan that was submitted by this, by the property owner at the time, and I don't know who submitted this, but it's this property, and it's to build the house plus maybe the second, the house that's built now plus the second house, and it shows the property line at the sidewalk or even on the other side of the sidewalk.
I'm going to defer to Mr. Bashara on that one. He's the man that drew the.
My name is Victor Bashara, 3000 Poston Avenue, Unit 403, Nashville, Tennessee, 37203. I'm the contractor and owned the property prior to Linda Norman purchasing it from me. I built the house. I owned the property prior to it, the house that was on it prior. I demoed the previous house. Couple of things I'd like to point out. First of all, no, we did not change the grade. Those trees have been up, probably 50 or 60-year-old trees on that property. And obviously, I guess they didn't grow overnight, but you can go out there and take a look. Those trees have been there, and the root systems on them, there was no change of grade. That is a retaining wall on the Whitland side.
So why was the retaining wall necessary if you didn't change the grade?
The retaining wall was already there prior. There was an old retaining wall. I went down to Public Works.
Did you demolish the old retaining wall?
Yes, I went to Public Works. I asked them if I could replace the old retaining wall because it was old and it was falling over.
Okay.
It was made out of cinder blocks, and the blocks it wasn't core filled. And over the time, from the trees that have grown on that property, there was some mature trees, and the root systems had basically busted, and the retaining wall wasn't secure. It was, eventually it was going to fall down.
But it was a true retaining wall before you. It was holding back dirt.
Yes.
It wasn't a decorative.
Correct. And I have pictures I can give you all too that show it is a true retaining wall, and there is holding back dirt. If anyone wants to go and walk down Whitland, you can see some very mature trees on the property, and you can see that I did not fill or add any dirt around those trees. You can see the root systems. That is the existing grade of the property. And to answer your question, I purchased the property and did do the HPR on it because it is an HPR lot. And the illustration that you just showed that had the zigzag on the second house, first of all, I never pulled a permit on the second house. That was the HPR that was performed, which I did do. And where you see that zigzag on the back on the property for 197 Bowling, which is the one next door, where zigzag, that is the rear setback, which is 20 feet. And yes, I did plan that house to put a second home there, and it does have a rear setback of 20 feet. So that's why you see that zigzag, because that was actually part of the house, and we came up with that 20-foot rear setback.
So the 20-foot, so I guess when you bought the house, did you have a survey done?
Yes.
And is the property line where the fence is?
When we had to do the HPR, as you all know, you have to go and do comparability. And you go down and you take your 4 houses down the street to find out what your front setback is going to be for the first house we did. And at that time, we did have a survey done. No one had ever asked me for a survey or to see it. Up until today, this is the first time. Before I constructed this fence, I went down and spoke with Mr. Bill Herbert and with Byron Hall. We had a lengthy conversation, probably a 45-minute conversation, making sure, because prior to Linda buying this property, Miss Norman, I had gone down there to make sure, because there was talks of wanting to put a swimming pool on the property. And obviously, if they had a swimming pool, they wanted this fence up. And I had a long, lengthy discussion with Mr. Bill Herbert and with Byron Hall, and obviously that is the Whitland is the rear of the property, because obviously Bowling is the front, and they said, yes, Victor, you're allowed to put the fence up because that is the rear, Whitland is being the rear, and the whole issue about the retaining wall, that is a retaining wall, and yes, the fence could go on top of the retaining wall, and now I've constructed the fence. I actually put the posts in the retaining wall before we core filled it, so all those posts are set in that retaining wall and being core filled. And they said yes, that I agree with the codes administration. I mean, you guys do a lot of hard work, and we do go by the codes book. and that's what we basically did. It is an irregular shaped lot. It's not like a traditional triangular lot where, there is no side setback.
So, but the question was, did the survey that you had when you bought the property show the property line within the sidewalk?
I would have to go back and look at the survey. I don't have it I don't have it with me today. I didn't know I was supposed to bring it.
Well, is your recollection, you don't recall it being over the sidewalk?
I don't recall it, no.
And the drawing that you have, the drawing that's submitted in the packet, in our packet, that shows that 20-foot setback, rear setback.
Could we clarify what page of the packet you're talking about?
On the public packet, it's page 98 of 314, in the board packet that's online. Yeah, that drawing right. Yeah, that drawing right there.
And your question again about this drawing?
Well, that drawing right there shows a property line that's used to get to that 20-foot dotted line. Appears to be, in fact, it doesn't appear to be, it is in this, on the other side. It basically is exactly where that fence is. It shows the property line exactly where that fence on Whitland is.
The back on the Whitland, the dotted line?
No, the dotted line is the 20-foot setback, and
Correct.
then the solid line that is a constant 20 feet from that dotted line is right on the sidewalk. So, I mean, it appears from this submission that Dale and Associates did, and it appears to be from when this was plotted as an HPR, or it shows the property line and kind of where the fence is. So would there be any reason to think that the property line is somewhere different than what this drawing shows or where the fence is?
Let me say this, if I might. I don't think that what is determinative is the drawing by Dale. I think what's determinative is what the decision that's been made by the zoning administrator, going by the established practice that's been down here for 60 years. The burden of proof is on the appellant.
Right. Well, and they
haven't presented a stamp survey.
And, sir, I would say that what this from
This
Dale
is
and
not a
Associates.
survey, I don't think.
No, it isn't. And this is what it's showing from Dale and Associates, as you know, that is the setback summary showing the 4 homes down the street, showing what the front setbacks are. And then they take the average of those to come up with what the setback was for the house that I built. That's what that shows.
Regardless of where the property line is, why would if that sidewalk is not part of the street right away, what is it? Because there is no definition in the zoning code of a sidewalk right away. And I think the point they're making is that that's part of the street right away.
Well, there's no definition where the street right away is, and we don't know, and that's the ambiguity here that I've been talking about. And it could just as well be that the street right away stops right at the curb, and the sidewalk is put there just like utility poles are put there, because you've got an easement to use it on your property in the front for a public use.
So the other side has said that the street right-of-way is platted by law at whatever, one side 59 feet, one side 60 feet, and that the whole thing is street right-of-way.
There's no public evidence of that. There's talk, but there's no evidence of it. People can say what if I'm understanding what.
And when you say there's no evidence, are you saying there's no evidence here today, or no evidence in general?
Here today. Here today. But what I'm hearing is somebody. If I may have misunderstood.
What would you? If you're saying that street right-of-way is different than that grass strip in the sidewalk, that has something else, that it's something else, what is it? What do you define it? Because if the property line is where the fence is, and in my mind, there's no reason to think that it's not. And and I understand the burden of proof, and if we need to have a survey done, then that may be something that we end up having to say we need before we can make a decision on this thing. But I think to me, there's evidence that suggests very strongly that the property line is where the fence is. And if the street right-of-way truly ends at the curb, what do you call the grass strip and the sidewalk? What is it? Is it just public land that is between the, I mean, what
No,
is
I
it called?
think it'd be public. It's my position would be, based on the evidence here, it is private land that there is a public use for. The public can use it by easement. The fee simple lies with the property owner, but the public has got the easement across it. And because you see the utility poles are planted there, you see the sidewalks planted. That's just like when you've got two lots together and you've got the power line running down the middle, or the sewer line. You're the fee owner, but there is an easement for the public use, public utility easement, same principle.
And I get that
I don't know why
argument.
I'm not communicating.
No, I understand what you're saying, which is the sidewalk is an easement, but the point they're making is you couldn't build within that sidewalk area, so how do you, I mean, you would concede that, I mean.
Because you'd interfere with the public use, the public easement. You can't, the easement that the public has or the utility has, you can't interfere with that. That's the easement is the dominant estate, if you will.
Sure.
And so that's why you can't put the fence in the middle of the sidewalk.
Well, and I get that. You could not obstruct the sidewalk, but what would prevent them from putting some kind of decorative fence in that was 2.5 feet that didn't obstruct the sidewalk? Or your position they could do that?
Well, you could, and I don't know if there are any safety regulations that would prevent it, but it'd certainly have to be a very low fence because of, the rules about obstruction. Right. And I imagine there's probably some rule about putting a fence of any height up within 2 feet of the curb, which is what that would be.
Okay.
But there's been no permit pulled to build the second house. And if we could show some pictures, Ms. Lamb, I would urge the board to treat my client consistently with what else has happened around her property. And it didn't just happen, it's been there, but you're going to see from these photographs, and this is on the southern boundary. You've got Bowling, Whitland, and then on the south. That's going along her southern property line. That's the neighbor's fence. Then now you see the retaining wall with a fence on top of it. That's at her northwest corner, southwest corner. And then you see there's the retaining wall. So see, that's what she's looking at. And now granted, that's side, that's not front. But you've got the rear line is what applies to Whitland. And I would also refer the board to the fact that in the zoning regulations, it says when this is 1712.040B, setbacks for irregular shaped lots. Whenever a lot is of such irregular shape that the setback provisions cannot readily be applied, the zoning administrator shall interpret the application of the setback provisions. And I think that's just what's been done here. And I think that statute, that ordinance, calls for deference to the interpretation by the zoning administrator. And I believe that's all I have, unless there's some questions.
Any questions? All right.
I would urge
sir. Thank you.
The board to make the decision today based on the evidence properly before you.
Thank you.
So they're saying that the
I forgot one thing. We have taken down those panels to comply with Public Works on the visibility. It's not going back up. So that's being done.
Thank you.
That's a non-issue.
So their position is the street right-of-way ends at the street curb, and the sidewalk is not part of the street, the street right-of-way, that it's a separate easement.
Can I get to that
goes
straight
through-
away with their papers?
Pardon me?
With their papers?
Okay.
That they submitted as a part of their building permit application?
Can you tell us where you are?
You've got I heard mention of the Roydale survey, at least in the packet I'm looking at. Then you got a building permit application, and then a sketch by Bird Surveying,
I think it's page 98.
and then Exhibit B. Do you have that?
Give us 1 second, Mr. Holland. The piece of paper you're holding up, I'm telling my colleagues, I think is 98 of our packet.
Yeah, the one I was referring to, I think is 98, and I think this one you're holding up have the landscape shaded. Yeah, that one I think is maybe 101. So it's either page 98, excuse me, or 101.
And I will, to Mr. Pepper's question, I doubt this is in your packet, but if you look at their, the documents that form their HPR covenants, that actually shows, and I don't have this printed out, I'm happy to email it over to get it to y'all. It shows like a sketch of their property, very similar to the survey that y'all are looking for and pulling up, and you can clearly see that it has the road, just the name of the road, then a curb, and then property line further back. So I'm happy to, I can send that in. I just didn't realize, again, that this was going to be the main issue today, so.
Is that a survey that is that a survey that you have?
Looks like it's attached to a survey of the front
Okay, I have a setback summary.
elevation. It's stamped by John Payne, and this is the next document.
And I believe what Mr. Holland is referring to, and Jamie, correct me if I'm wrong, that is there was a permit pulled, it is now expired in e-permits for that second house. And so that's where we are finding and referring that to, is there was a permit pulled to build that second house, it's just expired.
I wanted to quickly, some of you know I was manager of land development at planning for 7 years, and during those 7 years, we did plats every day. That's what we do. What we're debating, unfortunately, really isn't debatable. This is platted, and this was platted, it's the Whitland subdivision in something like 1910 with right-of-way and private lots. That's all it is. You have right-of-way and private lots. And the Department of Public Works, where someone here would tell you, they don't build their sidewalks in people's yards. They build them within that right-of-way. So we're debating, unfortunately, something that's it's established law. The public record of the plat is available. Everything is out there. These sidewalks are just not on the private property.
So
it is public right-of-way.
They're not, you're saying they're not easements?
Well, since we know each other, we could talk all day about easements and right-of-way. Right-of-way is really just a big old easement.
Right. Okay.
Right-of-way is a form of an easement for the public use, and that is all a right-of-way is. So when you say the right-of-way, that's what it is, property line. It is just every setback has been measured forever from that, like the houses are measured from the back of that sidewalk. It's just, it is what it is. That's all I had to say.
Metro owns,
I have a question.
Metro owns from back to sidewalk to back to sidewalk.
I have a question for Mr. Kleinfelter, just because I don't understand the right-of-way part. When we hear sidewalk cases, we often have owners agree to dedicate the right-of-way for later public use.
Correct.
So how, in this situation, how is that different? I understand what you're saying. It's all public lots and right-of-way. So just distinguish that for me.
You would, in those cases, you mean the cases where you're not moving the sidewalk? You are dedicating right-of-way, and the edge of right-of-way would be wherever that was shown as dedicated by the documents recorded with after you're required to do that.
Isn't it mine to give?
I can address that.
He's probably done that
encountered
part
a lot.
more than I have.
What happens is that Metro owns from typically back of sidewalk to back of sidewalk, which is called the street right-of-way. Within that right-of-way, there are easements for utilities, electrical, sewer, water, all that. It's not unusual when a developer redevelops a lot for them to improve and even address the curb and part of the pavement. That is work that's done by the private developer on public land and is deeded back to the public. So they don't retain ownership of those improvements they put in. It still is part of the right-of-way.
If I may, for the record, just because this may go up, Mr. Stewart, how many years were you an architect with Vanderbilt?
I'm still 40 years of architectural practice here and director of planning at Vanderbilt Medical.
I just want to make sure that's clear that he can be an expert. He's not just a neighbor.
You're not just a neighbor.
So once Metro constructs the sidewalk, it becomes right of way. And then what you do before, if you dedicate part of your land for a sidewalk, Metro puts the sidewalk on it, it becomes right of way.
It is right of way prior to the building of that sidewalk, or you will have dedicated more right of way within which the sidewalk can be constructed. But it is already right of way.
And so when you're talking about the dedication on those cases that are coming before you, it's because that where those parcels probably are, there is not enough right-of-way for the upgrading it to the standard with the planting strip and that sort of thing. And so that is what the council's intent in that legislation that Council Lady Henderson that we passed last term. It was because in a lot of areas we have to buy the right-of-way. We have to increase the right-of-way. We have to buy people's property, right? So we can have that planting strip and then the sidewalk. And so, like, for example, 37th Avenue sidewalk that is being built right now, it has taken 4 years to get to this point because we were negotiating purchasing the right-of-way. So purchasing property from homeowners because there wasn't enough right-of-way there. Here, Whitland, being such a historic neighborhood, when it was platted, it was, the right-of-way was big enough. I think it's 60 feet here is what it's being shown and that I've seen on the major and collector street plan. So there was enough for this sidewalk. And then, you see that in my other historic neighborhoods where the sidewalk was planned for, right? But then you see it like when you're in Hillwood, obviously a sidewalk wasn't planned for there. And so that's where we're having to get those easements. And that was, again, that's part of our, you can see that in our legislative intent, and that was that legislation.
I wanted to mention that setback and the property line is very important, that within certain zoning districts, being residential zoning districts, it's very clear that you measure the setbacks from back of property line. And if you want to have a distinguishing so you can see how it's done differently in commercial districts, most of them, it's measured from center of right-of-way. So it's the point being that they say the platted right-of-way is very relevant for that purpose. And it's not platted as right-of-way until it's been dedicated. It's dedicated upon platting in most instances, and other times you have to dedicate more because the city decides they need more right-of-way.
Thank you.
So Cyril, did you want to finish up with the position of the neighborhood?
If I close the loop on this, it's whatever's in page 98, 99, 100, 101, whatever it is part, Mr. I guess the homeowner's lawyer mentioned that, there's no countervailing evidence to the contrary. This was submitted by the homeowner. This is an admission. It clearly says where the property line is. Even if it's wrong, they've admitted that's where the line is, and I would submit to you that's where the line is. Thank you.
And in closing, for the Neighborhood Association, we were delighted that this new neighbor's moved into the neighborhood. We're glad to have her. Simply, all that we're asking is that this fence be brought into compliance with current codes. That includes the setback from the property line. That lot line is established by the survey that they submitted with the building plans. And if required, the Neighborhood Association would be glad to foot the bill for surveying that, just to clarify where that property line is.
And could you please also clarify for me exactly what you believe is in compliance?
I think both of them neglected to do the setback. Within 10 feet of the right-of-way, you can only be 30 inches tall. So both sides are not in compliance. The other thing that I think is that retaining wall should be included as part of the height of that wall. So it should be measured from the sidewalk up, not be 12 feet tall, but within that height.
And you can see that again. If you, again, looking at the pictures that we submitted, you can clearly see where the wall was and going back 10 years. And you could see the topography from Bowling to the Whitland side, and then you can see it in the current day ones as well. So, thank you.
Good. All right, any other questions? All right, thank you.
Thank you
Close
for your
public
consideration. Thank you.
hearing. Close the public hearing and discuss. Glad I have 4 lawyers with me.
Have you got it figured out, David?
No.
Lead us along.
Well, I do think that the zoning administrator is correct in the issues that are referenced, and that is, you know, it does boil down to, is the fence too tall on Whitland? You know, and I think that, you know, the disability triangle and then the setback on Bowling, and it sounds like that the disability, the public safety triangle, that piece of it has been addressed either way in terms of them complying with codes and taking out that part of the fence. And to me, it, and I really don't have an issue or a reprimand or anything like that to say that the interpretation of the rule that has been used has been inappropriate, because I'm not sure, you know, again, with the absence of a survey, not necessarily on this property I think is different, but in general, there was some talk about that. And I think I don't have any issue with that rule of thumb, because I think most of the time it's right. I mean, I think I'm almost 8 years on this board, and I can count maybe half a dozen fence cases, 4 or 5 I remember, and the other 3 or 4 I think are the new ones with the chain link fences and car lights, which are have all been brought because of a complaint, which is a legitimate complaint. But I think how they've been doing applying the code has been working. That said, I think the code, what we have to decide, to me, is does that rule of thumb work here? And is there a difference in the, you know, in this rule where it talks about 2.5 feet of height with and 10 feet of a street setback in A, but then in C it talks about you know, 8 feet, you know, in height on the rear. Do those conflict, or those, you know, which one basically takes precedent maybe in the back, in the rear setback, or, you know, if you read it in total, does it still apply at 8 feet or 2.5 feet on the Whitland side in the rear setback? I think the other question of the fence being too high on the Whitland side has to do with the very first statement in this rule, where it says the maximum permitted height measured from the finished grade level on the side of the wall with the greatest vertical exposure. And, you know, does that argument, you know, hold up according, you know, from the, I'm going to say the folks opposed to the fence. I still am not 100% sure who's the applicant. I think they're opposed to the fence. And then, to me, the one on Bowling is, if it's the front yard fence, is it, you know, does that, you know, where's the property line? I mean, because we've heard, you know, the code staff say, you know, it's 10 feet from the property line, and that generally has been approximated as, you know, from, you know, it's generally acceptable if it's from the curb. And I think that probably applies an awful lot to side fences and rear fences that don't have this type of neighborhood impact or opposition. I think there probably, as the applicant said, there probably are an awful lot of non-compliant side fences, you know, on corner lots that, you know, people don't, it's not bothering folks or the neighborhood, and so nobody's turned them in, but it has probably met this rule of thumb, which satisfied safety concerns and other concerns that the codes may have. Again, in absence of a survey, I don't know how you can determine this in the absence of a survey, but the applicants in this case said, no, there has been evidence presented by people who own this property, maybe if not the current owner, the developer, that showed where they thought the property line and therefore the resulting house setbacks, and the house is clearly, even though it's not built, the proposed house was clearly altered to reflect that setback line, which was based on the line where that fence is. And so we didn't ask the developer, but I've never met an architect or a developer that erred on the side, I mean, not erred on the side of caution, but that, if that setback line could have been a few more feet back, it surely would have not made it as zigzaggy, and it would have been probably an easier house to build, and they're gonna put it where they can put it. So to me, that was pretty convincing evidence of where the property line actually is, and I think it's now the board's decision to figure out if knowing where the property line is this fence a legal fence? Y'all are the lawyers to.
You keep talking about the lawyers.
I know, well, so is that, well, I'll ask our lawyer. Oh, thank you. Is that a reasonable assessment of what we need to decide at this point?
I would say it is reasonable. And I mean, also, when you look at I think what it states specifically is street right-of-way. So I think that's going to be important to your how you define what a street right-of-way is, maybe versus a different type of right-of-way. So,
Is there a different type that?
It specifically says street right-of-way.
And Cindy asked the question that I was thinking about sidewalks and how we ask people to dedicate right-of-way. I know that sometimes alleys run up against right-of-ways, and it runs up against a private property, and that an alley, if it's traffic going through it, I would consider that a street right-of-way. I know that there's right-of-ways for electrical and sewer that run through people's properties, but that doesn't change the designation of their property. That just means we give you permission to use this. So from my perspective, I don't know, while I'm certainly sympathetic to the neighbors, I don't know if the sidewalk is where the street begins, or if there was a problem with the way that the code staff did it and followed street and went from the street to the property line. So I don't know, a survey might help that, but from my perspective, it seems like it designates what a street right-of-way is compared to maybe like a sidewalk or any other type of easement that property owners give to the city.
Well, and I guess, and I may ask our legal counsel too, I mean, the applicant had said, and I guess if you look on Metro Maps, I mean, it says, kind of a street, and then there's that other person's property. And it doesn't divide it up as, I mean, it just is, this is the street, and this is, so is the street right-of-way strictly just where the street is, or is it where the street could be? Is this getting too caught up in?
I mean, I don't think there's a specific definition in the code for a street right-of-way, so I think that's what the board is going to have to determine. Absent a specific definition in Title 17 that says this is what a street right-of-way is, the board is going to have to tackle that question and make a determination of what you consider the street, what is that street right-of-way, and where you begin to measure.
I mean, when, and I know there's, in a lot of the public transit conversations that the city's had over the last couple of years, it's been widely published, the concept of a complete street. And the complete street starts with sidewalk, grass strip, bike lane, parking, drive-in street, and then flip it on the other side, and you get the same thing. And they, it was in kind of the planning, language, it was the sidewalk, grass strip, and bike lane, and all that was part of the complete street, which says, in that 60 or 59 feet of land that the city owns, is all that considered street? I mean,
well,
and I guess, to me, I guess the question is, and I asked it early, and I didn't get, I asked the zoning administrator if you knew exactly where the property line was, because when it was being described as, hey, if you're 10 feet off the property line, and we don't know where the property line is, so we've just said, we'll take it from the curb because it's not required, but I asked if you knew exactly where the property line, would that change your analysis? And the answer was, yeah, we would look at it based on the information presented. And I didn't take it further to say, well, then would you, consider the property line the point where the 10 feet starts. But I guess that's kind of why we're caught up in this whole question, is that because codes has never required a survey for a fence, and like I said, since we've only heard half a dozen in 7 years, there's no need to require that for everybody. It's not an unreasonable approach, but if given a survey, would that change how you do it? And does that mean that it really is the property line, which it was stated? Then I think that's why I think we're maybe going around and around.
So let me break it down and start with bowling. I don't think we need a survey, because I think the question for us is that sidewalk in the street right of way? And in my opinion, it has to be. I mean, there is no definition of a sidewalk right of way. I understand that the zoning administrator and zoning have used this rule of thumb, but I think the applicant makes the much stronger point here, which is that there's no definition for that other than it's part of the street right of way. And we know wherever the property line ends, we know where the sidewalk ends, and we know that this fence is within 10 feet of that. So with respect to Whitland, because the issue there is essentially, can you put a fence on top of a retaining wall and essentially count them as separate? And I don't think that you can. I don't think the code contemplates that. And I think that if you do need a retaining wall for topographical reasons, and then you want to put a fence on top, and the point you make is, what if you need a retaining wall that's 8 or 10 feet tall? I think that you have a remedy there, which is to ask for a variance. But I think that what was contemplated in the code is that it says screening walls or fences. So I think that it's contemplating that you can have one up to 8 feet, I believe it is 6 or 8 feet, but you can't tack them together and have separate 8 foot or 4 foot that goes over, or 5 feet or whatever. And I respect that the rule of thumb that has been used is to measure from essentially the end of the street curb, and I think that's been a practical rule that's worked. But as a matter of law, we've got to determine what is the street right-of-way. That's our responsibility here today. And if that sidewalk is not part of the street right-of-way, it just has to be. To me, nobody's given me a reasonable explanation of what it is if it's not part of the street right-of-way. So I think that the zoning administrator erred in issuing these permits.
Ross, or Mr. Pepper, can I ask you?
Sure.
I just want to make sure I understand, because I think I agree with you. Specifically on the Whitland, though, you are saying that you can't have a total 8-foot retaining wall or screening wall with a fence. Can they be a sum total of 8, in your opinion?
Yes.
But anything over 8 would come down?
Anything over 8 would, that's.
I just want to make sure I understood your.
Now, I'm sorry, go ahead.
Yeah, I was just making sure I understood.
So do you,
and I think
is the fence, I'm sorry, the fence on Whitland, because it's 11 feet and it could go to 8, or because, I mean, I think that the applicant had made the case too that because Whitland is, you know, a street, and there's a street right-of-way there, that the 10-foot, the 30-inch fence to 10 foot back on the property would apply even though it's a rear setback. And I think Code is distinguished between, again, based on the property owner's argument that, you know, hey, if it's an odd-shaped lot, this is clearly an odd-shaped lot, that you may have to make different interpretations. But so I guess, do you find, you said you thought the zoning administrator erred on both cases, but specifically on the Whitland side, is it because it's 3 extra feet, including the retaining wall, or is it because it should only be a 30-inch fence because it's so close to Whitland?
Well, and I may have misunderstood the issues, but from what I understand, I think that they erred because it's 3 feet. It's 3 feet above 8 feet. And I thought that was the issue before us, and I thought that's what the applicant was, I thought that was how this was framed up by the applicant.
No, the applicant, I thought, well, the applicant talked about the height, but I think, and I don't know, do we?
Well, I asked the applicant, and I understood them to say, we think both of them are too close.
Yeah.
That we think they're both in the setback. Okay. But I don't necessarily agree on the Whitland side. I tend to agree with the zoning administrator that the fence is appropriately located, but I disagree in that I believe it's too tall. That's where I'm headed anyway. Is that where you are?
I think that's where I am too. I think it is too tall.
But you're agreeable for it to be closer than 10 feet or within the setback?
Yes.
Okay.
As I understand it, yes.
So because it's a rear setback, rear setback fences are allowed on the property line. You agree that it's a rear setback and that it should be on the property line, but it should be 8 feet, and it's measured from the lowest point, which is the sidewalk.
The retaining wall.
Yeah, from the retaining wall, from like the level of the.
Ground up.
Yeah, from the ground at the sidewalk, not the ground on the inside of the fence.
Well, let me make clear, I don't like it, but I think that's how I would interpret the law on what we have to do on that side. I don't like it at all.
Well, then the question comes in, when you're measuring from the ground, which side of that wall? Because the ground's going to be higher on the side that needs the retaining wall.
It says with the most vertical, greatest vertical exposure. So I think you'd have to go from I assume that's the sidewalk side and not the interior, I assume. Is that?
Well, and I will just confess, I don't have my mind around this issue because I studied these materials before this hearing, and what I understood the applicant, their position was, within the side setback, a fence or wall may be constructed up to 8 feet in height. So that's what I studied coming into this, and so I would, you know, I just didn't catch that when we were going through it. I was focused on what their position was, yeah. So I'm fine with that.
But you're not sure about the placement of it?
Well, yeah, I just don't, you know, I'd have to go back up.
My thought is, I was kind of leaning toward, I'm sorry, I was kind of leaning toward what Mr. Evans pointed us to. I do think that the zoning administrator may interpret the setback provisions on irregularly shaped lots, which I believe this is, and therefore as to that Whitland side, I think he can say that the fence is acceptable in that location. I just disagree with him. I don't think it can be as tall as it is. That's all I'm saying on Whitland. I agree with you on Bowling as to the right of way.
And do you agree on Whitland that it can't be over 8 feet?
I agree that it can't be over 8 feet from the,
it can't be over 8 feet in height.
correct.
But what you're saying is.
The sum total of the wall and the fence cannot be more, this is my interpretation, cannot be more than 8 feet from the side of the wall or fence with the greatest vertical exposure, which means you would measure it, to me, from the outside of the fence.
Okay, and I don't think the applicant has a problem with that. I think they're saying that they're okay with it up to 8 feet in height. on the Whitland side.
Okay.
But apparently it's more than 8 feet, and that's the
Yes.
issue.
Well,
That's
yeah,
what
I heard they didn't like both, but
Yeah.
that's what I'd heard,
That's
that
what I
they,
think, they didn't like both.
I mean, I think that they would prefer it to be a 30-inch open fence like it was for 60 years or
When it was
whatever.
beautiful. It looked better.
Did you have anything else to say?
Well, do we have any issue on if they remove the panel, like the visual, for the safety concern on removing those panels that are removed? Are we,
Yeah, I don't think that's even before us because
Yeah.
that was cured. I mean, they,
Yeah, that's what I understood.
okay. What else?
well, I guess let me, I really don't have a sense of where everybody is on it, but do we want to take both pieces separately? It sounds like that you all were talking about, basically it's the fence on Bowling and the fence on Whitland. And
I think taking them separately makes sense to me.
so let's talk about the Bowling side fence that appears to be on the property line in the front.
So I would move that the zoning administrator erred with respect to the Bowling Avenue part of the fence.
And is that based on the evidence of an actual property line?
No, it's based on the fact that the sidewalk should be included within the street right-of-way. And my understanding is, once you do that, then you're within that 10 feet. In other words, my understanding is the zoning administrator has measured from the 10 feet from the edge of the street.
Right.
And so currently their fence is outside of that 10 feet, but if you were to include in the street right away the sidewalk, then they would be within that 10 feet. So
Yeah, I mean, I guess
they're
my
above
logic would
2.5
be,
feet.
I guess my thinking would be slightly different, same conclusion, but slightly different in that the two documents that were presented not by the property owner but by the appellant that were at some point presented by the property owner, two codes which showed setbacks and property lines that would have been based on setbacks, showed that the property line was on the other side of the sidewalk, probably just on the other side of the sidewalk, and that it should always be the property line that establishes the fence rules, because even in those cases that, where someone is given an easement for the city to use their land, I don't think that piece, I think that truly is their land, and it's not public land, it's their land that they've given to the city to use, and the city's taken responsibility for it. That in those cases, that property should be able to build 10 feet from their property line. And so that's where I think property line's important. In this case, I think it's the exact same spot,
I think what you're saying is you get to the same place.
I get to the
We disagree about what the issue is.
I get to the same place. I just, if anybody was looking at it down the road to say, well, does an easement mean that it starts there and it keeps pushing it further and further back? I don't necessarily agree with that. I just think I think it's property line based, but, and I think there was evidence there was evidence enough of where the property line is to say that this fence is within 10 feet of that. And that really, to me, that's where I would get to your spot on the Bowling side.
Is that a motion on Bowling?
Sure, so I'll make that a motion.
I'll second.
I have a motion and a second on Bowling. Is there any other discussion? All in favor, say aye. Raise your hand. Any opposed? All right, that passes. And the Whitland side. And, and to me, I'm looking at a street setback or a street right-of-way, which this certainly is, but then balancing that with the, odd-shaped lot and the zoning administrator's determination. And I mean, I think that there is always a front and a rear, but to me, how does A conflict with C in this rule and then the other rule that was presented to say, hey, in odd-shaped lots, there's some flexibility in determining this.
Well, do we need to go there? Because if the fence is over 8 feet and we find that it's non-compliant, doesn't that satisfy, isn't that what we're supposed to do? Do we need to determine more than that? And are you trying to maybe?
Well, I don't know that, I guess the question is, if we said it's non-compliant because it's 11 feet, and then they cut it down to 8 feet, and the neighbors still complained and said, wait a minute, you didn't answer the other question, does it?
How tall can it be?
We've all sat here for 2 hours, we have to sit here, I mean, I don't want to bring everybody back. So I'm just saying, if we can answer, if it's possible to at least address both, that'd be great. And then at least our opinion, this board's opinion is settled, and folks can accept it or take it to the next stage.
Okay.
But I don't know that it has to be.
Well, I think you make a good point, that there's no sense in doing this twice. So we've had a couple-hour hearing, so.
Okay, I'm going to make a motion on the Whitland.
Mike.
Oh, I'm sorry. I'm going to make a motion that on the Whitland side, that we have 2 determinations we're making. 1 is the location of the fence, and 2 is the height of the fence. My motion is that the zoning administrator did not err as to the location of the fence, but that he did err as to the height of the fence, and that it should be no more than 8 feet in height.
I second.
And that's from the finished grade level of the wall or fence with the greatest vertical exposure.
Yes, that's pursuant to,
Because I think that it was the zoning administrator said it was no more than 8 feet on the inside, but you're saying no, it's from the greatest vertical exposure.
that's what I understand the law to say. So that's what I'm basing that on, which is 17.12.040 E26.
All right, so we have a motion and we have a second. Is there any discussion? All in favor, say aye, raise your hand. Any opposed? That motion passes. All right.
Can we take a break?
Yeah, we're going to take a 5-minute break and then we'll reconvene.
Hollow Road. This is a request for a variance from the side setback requirements to construct an addition on the side of a single-family home. Is the applicant here for case 480? Yes, you can come forward to the front table. Before you is a zoning map showing the zoning of the property is RS 80. Aerial photography giving you a sense of the property and surrounding area. This is the site plan submitted by the applicant. And finally, the current conditions of the property. Is there anyone here in opposition to case 480? Seeing none, the appellant will have 5 minutes. Make sure you identify yourself by name and address, please.
My name is Ryan Tavis, 165 Leelwood Circle, Nashville, and I'm an architect representing the client on this property. They had hired me. They were in need of more space, so we kind of went through the design process, narrowed it down, found the optimal place where we could add this extra space, which happened to be on the side of the existing house. And after that, the client got a survey together, and at that point, we discovered that the side setback on that side of the house is 20 feet, which includes a 10-foot public utility easement as well. And so And that's, we were hoping or asking, because it's a really irregular lot. I mean, we're really out of options on where we're able to add space to the needed space to this. So what we're hoping to do is push into that 20-foot side setback, but actually stay short of the public utility. We don't want to get into that public utility, but we're only wanting to go 10 feet into that 20-foot setback.
So you're building a 10-foot by 34-foot addition, a 340-foot addition?
Yeah, one story, yeah. And we do actually, it came in kind of late. We were hoping to have it before the meeting, but we did get an email that we forward on to, from that neighbor that's on that side that's in support of this.
That was my question.
Yeah.
What does the next door neighbor think?
That in support of it. We were hoping to have it beforehand, but didn't.
Is there anything else to add? Any questions from the board? Nothing else to add?
I don't think so, no.
All right, then we will close the public hearing. I don't have an issue with the request. Is any?
It's obvious from the map that it is an irregular shaped lot,
and
that it dips in and.
Well, and it's really the only side of the house that it could be added onto, and and the next door neighbor is okay. So I'll move that we approve the variance to the side setback per the plans that were submitted and based on the odd shape of the piece of property.
A second.
Have a motion, have a second. Any other discussion? All in favor, say aye. That's approved. Thank you. Good luck.
Thank you.
Next case, 2019-482, involving property at 404C Eastboro Drive. This is a request for a variance from the lot size requirements in order to convert an existing garage into a detached accessory dwelling unit. Before you is a zoning map. The zoning of the property is R8. This is the aerial photography showing you the property and surrounding area. Site plan submitted by the applicant is before you now. And finally, the current photograph showing you the current conditions of the property. Is there anyone here in opposition to case 482? Seeing none, the appellant will have 5 minutes. Please be sure to identify yourself by name and address.
Hello, my name is Travis Morse, and this is my wife, Devin. We are the homeowners at 404C Eastboro Drive. We have already existing, it was there when we bought the property. It's a 17 by 14 foot detached garage sitting in the back lot. We're hoping to add plumbing to it. It already has electrical. Like I said, the structure's already there. It's about 89 feet back from the front property. We are not adding any concrete. We're not taking up any land. We did pour concrete, but it was on top of existing concrete. We paid for a report of a house inspection, and we're currently working on fixing everything that they said was wrong with it. We've pulled permits to start working. We've started framing on the inside, adding windows. The only thing we're really held up on is adding the bathroom. I'm a pipe fitter by trade, and we've already scoped out the water. We've already scoped out the sewer. And one of the things they did mention to us is that.
Do you have a permit?
I do have a permit. I didn't bring it with me. I have a picture of it on my phone. I don't.
But you have a permit to do the work. You just don't have permission to have it as a bathroom in the daycare.
We haven't started anything that we haven't got permission for. The only thing is I just kind of scoped out where the sewer was. I have a neighbor on each side. Both of them don't care. One didn't even really want to talk about it. That's how little he cared. The other one is their grandparents, and they got 11 grandkids, and they all play in our backyard. And so we've already told them that, it's not going to be Airbnb. It's not going to be someone we don't know. The end goal is to get my mom in there when she retires. She's over on the West Coast right now. But she's still got to sell a house and retire. There won't be any extra people out in front of our house, like streetwise. I have like an 80-foot driveway, and it's more than enough for our car and whoever's car is going to be in that. We're not really looking for like a 404C and a half. We're just kind of looking for it to be part of our house. There's already power ran from the house, and we just really need the permit for the plumbing and water. And we're doing all the work ourselves, and keeping in touch with the neighbors. If we get too loud on the weekends and they just come over and tell us to stop, and we shut it down. And we talked to the neighbor straight across the street. She didn't have a problem with it at all. And
Any questions? Anything that you'd like to add?
I just answer any questions. I don't have much more.
It looked like your neighbor, maybe 2 doors down, they may have a larger lot, but it looked like they had a garage with a second floor. Is that an apartment?
They have, it's like a 2-story. I don't know, we haven't looked into it, but it is a 2-story detached, like
Yeah.
livable space.
You can
It's
see it in
got
one of the
power
photos.
coming up from the lines, but I don't.
Okay. Well, sometimes these cases that are lot size variances, it's sometimes important to some board members of, do your neighbors have the ability to do this and you don't? And, especially in folks that are, 5 or 6% off the required property like you all are. So that's why I was just asking if you knew what was in the one. I saw it in one of the pictures. It was clearly a room above a garage, and it appeared to be an apartment or a studio or something, but it.
Yeah. Well, they told, I believe the neighbor underneath us in that picture told us that all those lot sizes are all the same except for his. His was a little bit bigger, and so I think they're all 500 square feet off. Yeah.
I just wanted to ask the applicant, what do you think your hardship is in this case, like for the variance?
I feel like and I could be completely wrong, but I feel like the 8,000 square feet is for, well, let me start with this. They're building all the tall and skinnies in the neighborhood, and I feel like that kind of applies to that more. Like, we're not selling our house, we're not renting out our house, we're looking to make what's already there. And so I feel like my hardship is that 8,000 square feet kind of is more for like, what they're doing is they're demoing houses and building 2 or 3 in a lot, and like, we're not doing that. Like, I'm just trying to make what's already there a livable space.
So you're just going to convert it, it's not going to add any additional square feet?
Correct.
Okay.
Correct. Yeah, the only concrete that we've poured was in the report that we got from the inspector. I mean, you didn't need the report to see it, but it was all cracked and uneven, so we sealed it, sealed all the cracks, and then laid sand and then poured concrete on top to fix the slab. But we didn't pour concrete anywhere that there wasn't concrete already. Plus, we put in like 3 fence posts, so.
Any other questions? Anything else you'd like to add?
All
right, we'll close the public hearing. Thoughts?
My position usually is when the request is small in this manner, I think they're 6% under the requested size. They've already got the building on site and they're not looking to add to that. That's typically something I would support. I'm happy to turn that into a motion if y'all want to.
Yeah, I think that's fine. And I think day-dos, frankly, are different than second homes.
Make that a motion, that we grant the requested variance down to allow them to build with a 7,500-foot lot.
Have a motion, have a second. Any other discussion? All in favor, say aye, raise your hand. Any opposed? That motion passes. Good luck.
Thank you.
Next case, 2019-484, involving property at 601 Summit Oaks Court. This is a request for a variance from rear setback requirements to maintain an existing addition on the rear of the home. You can go ahead and come forward to the table. Is there anyone here in opposition to case 484? No opposition present. Before you is a zoning map showing the zoning of the property is R15. Aerial photography showing you the property and surrounding area. This is the site plan that was submitted by the applicant, and finally, you'll see the current conditions of the property as well as up and down the street. No opposition is present, so the appellant will have 5 minutes to make your desired presentation. Please be sure to identify yourself by name and address.
My name is Bashar Jabri. I'm the property owner of the 601 Summit Oaks, Nashville, Tennessee, 37221. When we It initially purchased the current property land for building. We have bought it with a building envelope of 46 by 44. When we get to the site and survey to start building on it, they told us we have to go back by 42 by 44. And that cut a place and actually space of my home, and we already done the permit on it, so we decided to go for it no matter what, and we can add the additionals on it as we have the deck in the back, and I wasn't sure about getting a permit for the additional. Because I was living in Montgomery County. They told me I don't have it, so I thought it will be the same. And I start building the addition on it. They told me I have to have a permit, so I stopped and came to get the permit. They told me that it's actually going to be the setback on it. You have to file like a variance request on it. And that's why I'm here. I'm hoping that I can get the approval to get a permit so I can finish up the additional.
And tell me what, you had a deck and you're trying to enclose the deck. Is it going to be air conditioned? Is it?
Yes, and I have a letter of support from both neighbors on both sides as well included with the file.
And so you're asking for a rear setback variance. What is the property like behind you?
There's no property. It's actually rainforest, like it's open.
Okay, I mean, it's wooded, right? I mean, you can see, so your property's the one in the red dot up here, I think?
Yes.
And so behind you is woods, but is it hilly?
It's kind of actually a garden, a rain garden behind me, so there's no neighbors behind me.
Oh, I see. That's what you can see. That's what you can see on this drawing. So you're saying that your property ends, and then the rain garden is really kind of the community's water retention pond. So there's nothing behind you.
No.
That would, and that may be one of the reasons that your lot's smaller, is because of the need to have a water retention pond behind you.
Yes.
So what you do have some neighbors that submitted a letter opposing it. Scopajack, and I don't think they're here, but how do you know where they live in relation to this property? They're at 593 Summit Oaks Court.
593. I'm 601, so I got like a letter of support from both neighbors on both sides.
Well,
and
these oppose. These they say, as owners of very close property to the property in case number 209484, we oppose addition to the rear of the house in the above case, and it's Scopajack, I believe, are their names.
And then we do have a letter from 601 supporting.
Right, yeah, I saw that one too. I think we got a couple supporting. What
598, I think, and 604, they submit. They're both on both sides of my home. They're side by side. And then I got like also my neighbor in the front of me as well. They already have like an additional. They told me they can be actually supporting with that. And I'm not keeping access to them to go to I didn't close it or I didn't put a fence, even though the majority of my neighbors, they have a fence on it, on the back.
You don't know the Scopajacks?
No.
All right.
But do I understand, your deck already goes, the existing deck, you are not expanding, you're just enclosing it.
I'm not.
So that deck is already 2 feet from
there. Yes,
your
ma'am.
setback? Okay. I mean, from your property line?
Yes, ma'am.
Any question? Any other thing to add?
No, sir.
All right, we will close the public hearing. One of the main things to me is like what was behind it, and it is part of the development, and as the stormwater is a fairly permanent part, and so I don't see any injury to the folks behind. So, and I'll move that that the curved, odd-shaped lot and is the hardship that warrants the motion to grant this variance. And I'll move that the variance is approved.
I'll second.
Have a motion, have a second. Any other discussion? All in favor, say aye.
Aye.
That passes. Good luck.
Thank you very much.
Next case, 2019-486, involving property at 4908 Aquatic Road. This is a request for a special exception to use an existing residence for a religious charity. Before you is a zoning map showing the zoning of the property is RS10. This is the area photography showing you the property and surrounding area. And finally, the current conditions of the property as well as up and down the street. Is there anyone here in opposition to case 486? Yes, so each side will have 10 minutes. The appellant, be sure to reserve rebuttal time if you would like rebuttal time, and then please be sure to identify yourself by name and address.
I am Brent McDonald. I'm the Executive Director of Cottage Cove Urban Ministries, and I'm here regarding our property at 4908 Aquatic Road. We are a religious 501c3 charitable organization that has been helping Nashville children and families for 25 years. Our highly structured program is built on a foundation of teaching biblical principles. On this integral underpinning, we offer academic support, life skills instruction, and experiences with musical and visual arts. A core part of our ministry is offering daily programs to children. And we rely on the volunteer spirit of Nashville, what Nashville is known for, and benefit from the generosity of hundreds of concerned individuals, university students, and professionals giving of their time to help with our programs annually. As a faith-based organization, our freedom of religion, which allows us to carry out our Christian programs, is key to our petition for a special exemption as covered in the Federal Religious Land Use Act and in the Tennessee Religious Freedom Restoration Act. We recognize that a vocal few don't want our ministry to operate at our 4901 Aquatic Road location and are stirring up opposition mostly by circulating mistruths as to what our ministry's presence in the neighborhood means and how it would impact their daily lives and properties. This opposition arises primarily from a small area, while our ministry will be serving individuals from a mile-wide radius surrounding the central location. Only a few nearby neighbors have dared to openly express their support for us. One summarized it well. And I quote here, "If we did, they would treat us as they treated you." And this comment was especially in reference to the highly hostile community meeting these individuals held on October 4th at Tusculum Elementary School. Only a handful of those notified by mail actually chose to attend our public house that we held on Aquatic Road on November 8th. Addressing the opposition that's been expressed to us, I'm going to give you the four major viewpoints that we've heard. Number one, there's religious opposition. I don't need to spend much time on this. Some openly oppose the distinctly Christian nature of our programs and don't want a conservative Christian organization, let alone a tax-exempt one operating in their community. And we're grateful the aforementioned statutes provide protections for religious organizations, with this board not having to judge the merits of our Christian beliefs, though we know such teaching will benefit these children their entire lives. Secondly, there's been racial, demographic, or political opposition. Some oppose us, fear things that are different than them, whether by personal attributes, economic status, or even political leanings. We'll be serving a diversity of the surrounding area, plus have a diversity of people serving with us. Cottage Cove's programs don't discriminate against people of color, nor do we discriminate over socioeconomic status. Our goal is to seek out those of greatest need, and helping single-parent families or those suffering economic or social hardships of all races and ethnicities is part of our living out our biblical principles we believe and teach. Thirdly, they've raised quality of life opposition. Some fear our building's appearance will look dramatically different than the homes surrounding us. One reason we selected this existing home is that at 3,000 square feet, this spacious property has plenty of room and parking for hosting children in our program without changing its appearance or size. While most of our program is inside, sound testing shows that our small group of children playing in the spacious backyard would generate negligible sound at the street. Plus, since Cottage Cove operates our after-school children's programs under Tennessee Code Annotated 71-3-503, with these programs running for less than 3 hours each day, there's a very small window of time when children would be outside, normally ending before 6 p.m. when most people are at home. Fourthly, there's been economic opposition. Some claim that Cottage Cove's presence in the neighborhood would reduce the resale values of their property by $30,000 to $40,000. And this is a scare tactic without merit or evidence. We've consulted with multiple prestigious appraisal companies right here in Nashville who confirm this isn't true. And I'm hoping he's now present. McGuigan? Yes, excellent. We have an expert witness present to speak to this concern, Pat McGuigan of the appraisal firm McGuigan and Associates. So in summary, we're asking your board to approve this special exemption request for religious reasons, knowing that Cottage Cove is endeavoring to help Nashville as a whole and the neighborhoods surrounding this aquatic road property in specific. Thank you for your consideration, and I'll turn my time over to Pat McGuigan.
Are there any questions right now for the applicant? One of the things that your council member had said when, at the beginning of this hearing, which may seem like yesterday to a lot of you, he talked about a couple of conditions that he would prefer that you consider and talk about. One is the maximum number of children, and to help us understand how many children you're going to serve and have us understand that and talk about is there a maximum number that if you decide to go over that you should come back and say, hey, we need to serve more children. Is that okay? No street parking, limited signage, and addressing traffic. Did you have issue with any of the types of things that he was talking about?
Well, as for not parking on the street, there's signage already to that. If you drive down that street on any given night, it's not us that's parking on the street. All the neighbors are parking on the street. I have picture after picture of that. As for having no lighted sign or small sign, that's something that at the public meeting that we said that we'd have no problem setting the sign back onto the garage so that it's back from the street. And, question with that by no lighted, I assume they mean no in-sign lighting, but, natural light that might be falling on it would be lit.
Sure.
I have no problem with that at all. The request for us capping the number of children, we haven't set an upward cap on that, but my understanding of the section of the law that goes with this is that it would be compelling governmental interest for you to have to restrict that, and you'd have to give us reason why you'd wish to restrict it. Where, we haven't at this point determined. All I know is that, it's a large facility at 3,000 square feet. The aforementioned 15 children would be a waste of space and a waste of our volunteers, because we run a rotation-based program where they come in, work with kids for, 40, 45 minutes, and then move to a different rotation of kids. So to optimize our volunteers, 15 would be a ridiculous waste of space.
Yeah, and I guess does this property have a swimming pool?
It no longer has a swimming pool. That was in our contract to purchase the property. The swimming pool was removed.
Okay, I just see it from the old aerial, and
yes.
This one, because you did talk about, and we have all had discussions on the religious freedom laws and understand those and know when you're talking about places for kids, there is some compelling government safety issues that are absolutely relevant. And so to some extent, this sounds like not a daycare in the sense that people drop their kids off and pick them up as a traditional, but it sounds like in terms of holding children that there are daycare type elements to it. And so
it's a structured program. A daycare is quite different than that. And also, that's why Tennessee law actually recognizes our program as not being regulated by DCS, not being regulated as a daycare.
Okay. Then, so you do have issue with setting a maximum number of kids, or do you just want a different type of maximum? Or would you say?
Well, again, I'd like to hear the compelling reason to.
The fire marshal sets physical body restrictions, and that has to do with having people not burn up in fires. Yes. That's pretty darn compelling. So that's a fire marshal call, not a zoning code call, not a neighborhood call. They don't set it, we don't set it. Fire marshal sets it. That's been upheld consistently in both state and federal courts. Yes. We don't set that here. However, you're never going to bump up against a fire marshal count in all likelihood with 3,000 square feet. However, to the question posed by the chairman, I think repeatedly, and I think pretty reasonably, sounds like the answer you're presenting is I don't have any problem following the fire marshal's guidelines. Have I misunderstood that answer?
Correct.
Thanks.
Yes.
Thank you. Okay. And then the other issue that they raised was traffic, and and cited some, and this was in the letters as well, citing some ambiguity as to, just how people are going to get there. And they said that, I think in the meetings that you or someone from the organization said, oh, we have vans that we're going to haul people. And then at some point, I think some people said, hey, it was said that people could walk, and they said it's a half mile from the school, and there's no sidewalks. And so
we would like to reserve both possibilities on that, because the neighborhood is actually friendly for walking. I was working outside there for 2 days last week and watched my neighbors walking their dogs, having their infants out walking them. It's a very friendly neighborhood for that. But we're hearing both sides on that, it's not safe for walking, but if you run a vehicle in the neighborhood, it's not safe because we want to walk in the neighborhood and you're running a vehicle. So we heard both sides of that.
Yeah, and I understand that could be frustrating, and I guess the only thought I have, and again, we'll hear from the opposition, we'll hear from the councilman again, but is to solidifying the plans, more concretely to as to how the kids will get there and how they want, so that any safety concerns regarding the children might be met also. So, I mean, I don't know that I have an answer. I'm just saying, throw it out there. Those are the things that.
I mean, our existing location is actually 0.7 of a mile. We walk with the kids. If we do, we are highly supervised, where we have a large number of adults walking with kids. The other part of it is that there's also the possibility of kids that actually live in the immediate neighborhood that would be walking. So, if you're saying that we have to drive, then are you trying to restrict that even that child that lives 3 doors over at the apartments at the end of the street, that they have to be, someone go picking them up, or are they allowed to walk in their own neighborhood?
I have a couple of questions. In your other locations, do you have children walking to and from? Are they primarily brought by a parent or primarily escorted by your volunteers?
It's a mix on that, because we also have buses that drop off at the bottom of the street, and the kids that from the middle school walk up to our location, so they're walking unaccompanied.
Well, at what point does your group feel like you're in charge of the children? I mean, you have people that are willing to walk over to school and escort them over.
Yeah, if we're walking with the kids, they are in our custody, and we're maintaining their safety on that at that point. But kids that are otherwise being dropped off, whether it be by a parent or by bus, then after they enter our property, then we take custody of them.
And what about a child walking alone? I mean, if they're as young as kindergarten, I mean, that seems young to me to walk alone.
And it's improbable for that to happen. I mean, most parents would not even want that to happen.
Right.
We've had in our locations over the years a number of circumstances, and we're more likely to have one of our older students accompany one of those child.
And are you contemplating 5 days a week of this program, or is it 7 days?
No, it's normally 5 days, weekday.
Okay. And what is it, like, for example, 3 to 6, 3:30 to 6:30?
Yeah, and under the section of the law that we work, we have to run for less than 3 hours a day. So we normally would have, from the time that school gets out, count off 2 hours and 45 minutes, and then that's usually our shutdown.
Okay, thank you.
Any other questions at this time? Did you have anything else to add at this point, or? I know you had someone else that you wanted to speak,
yes.
and then.
To regarding the issue of the property values being devalued, you'd like to speak to that? Okay.
Good afternoon. My name is Pat McGuigan. I'm a real estate appraiser. We have a firm, McGuigan and Associates, 16 appraisers. We do about 110 commercials a month, and then about 250, somewhere around $100 million of single-family values a month in single families. I've been asked by the nonprofit to look into our in other situations that have operations of this type. Is there a effective market value of the surrounding properties? And so the best way to do this is I found 3 locations, and just real quickly, I'll not get into real detail on each one of them, other than to say One of them was at Faith United Missionary Baptist Church out on Whites Creek Pike. And basically, I went and found one sale within the last year, and it was 1 block away. And then I went further away from the school or the church to find other sales at the similar period of time. And all these fell in the same range. I was 3 blocks away, 4 blocks away, 4 blocks, 4 blocks. And so all of those on that particular search there showed that there was no loss in value to the properties that were next or contiguous to the operation. Then the next one was Park Avenue Baptist Church. It's been operating, oh, by the way, the first one had been operating 11 years. Park Avenue Baptist Church has been operating 10 years with an after school. And in that particular situation, I found another property just 1 block away. And then I found other sales, 7 blocks, 5 blocks, and 6 blocks. All those sales came back with the same range of value per square foot, so there was no diminution in value there. And then the last one is Preston Taylor Ministries. It's been operating 12 years, and it is over on Indiana Avenue. And I found a piece of property across the street, and then I went 13 blocks, 12 blocks, 5 blocks, and in that search and with that data, I found no loss in value. So that's the extent of my study. I'll be happy to answer any questions.
Any questions? No, thank you. Appreciate that. You'll have 2 minutes and 45 seconds, 46-ish seconds for rebuttal after we hear from the opposition. Oh, sir, the extra, did you want to make, if you have any documents that you'd like to make part of the record, you can give those to Jessica at the end of the table, and she'll include those as part of the public record. All right, if you would, state your name and address and tell us why you're opposed to this project. And remember, everybody has 10 minutes total between you, so manage your time with the clock right there.
Okay, my name is Shelley Armstrong, and I live at 4904 Millerwood Drive, 500 feet from the proposed Cottage Cove Enterprise. And I'm not going to speak very long. I'll come back and speak. But I do want to just address a few things that Mr. McDonald said, because I feel that he slandered us as a neighborhood. We're all Christians ourselves, every single one of us. And so our opposition to this was nothing to do with religion. It was nothing to do with Cottage Cove itself. It is purely on the basis of where it is located and the logistics of where it is located. So I just want to go on the record as saying that we didn't even plan on addressing anything about the religious nature of this, but only the location itself. So I'll hand it over to my neighbors.
My name is Jennifer Polk, and I live at 4908 Millerwood Drive. I'm located within about 500 feet also of the property in question. I also want to note that I am an employee at his targeted school. However, today I'm purely here as a homeowner, not as an employee of that school or the school district. One thing we're concerned about is we would like to know his true plans for this location, not just today, but also for the future. We've had 2 meetings with Mr. McDonald and the Cove representatives, and they won't really answer our direct questions about such as how many kids will be there during the day. We also want to know, will he run his summer discipleship program, which brings in people from out of state to work with these kids? They also run a Christmas store where 350 to 400 plus families come and go shopping to find gifts for their children. If you start talking 400 families come in to go shopping, he does have a 1,200 square foot garage at this property. It is bigger than his existing places that he currently has, so it seems logical this would be where he would want to do that. They divide them up, and so on Saturday, they get to some come at each time. That's 25 cars an hour plus volunteers will be coming in and out of this location to go shopping for 2 different Saturdays. We also want to know, will he have dumpsters outside like he has at his Vine Hill residence? If not, how will he get rid of all the trash for these children? Will he have multiple trash cans sitting outside? Can our sewers at this location handle that many kids? These are old houses. I don't know if his has been replaced. Also, he has a bunch of children currently at Vine Hill. Will they be bused too, or will they have to stop the program? We're very concerned about losing the residential feel. That is the appeal of the neighborhood. Before I lived in the condos, and I drove this every day to Tusculum, and I sought out this house to be in this neighborhood because of how residential it is. While it does back up to Nolensville Road, it is like an oasis with very little traffic on Millerwood and Purnell and Aquatic. And I think you guys have pictures of their Madison location and their Vine Hill location, and just can compare and contrast that with what we have at this location. We want to know, will he try to put, like he did at Madison, a legal-sized basketball court? He has a climbing wall at Madison. Will those things be able to be allowed at our location? We are adamantly against those things, as well as a sign and the way the parking. If you look at the difference between the house before and the house now, the parking that was added really is very noticeable. There's 13 or so lined spaces, and there used to be a gate that hid most of their parking that's no longer there. I know Nash addressed our traffic and our sidewalks. Let me also say that he's going to need to find one way to bring them in and out, because Tusculum dismisses 795 children in 15 minutes. It is not feasible to call the school on a rainy day and say, hey, get your 30 kids, go to a different part of the building, because we're going to be picking them up today in a car, versus they're going to be walking. We have to dismiss from different part of the buildings, because that's 795 kids in 15 minutes. We have a concern about the lot. If you look at this picture, a lot of the property's in the front, not the back. He said he's going to terrace it so the children can have space to be in the back. We have questions about drainage if that happens. Also, will they have plans to be in the front yard? There's, like he spoke, we are out walking in our neighborhood a lot. We walk our dogs, we just go for walks. We're a close neighborhood. Children in the front are probably gonna really change, not only the feel of the neighborhood, but our ability to access our neighborhood as well. We have had a concern with the lack of transparency with him and their organization. I was asked by one of their board members, did I know when I bought my house that this could happen in my neighborhood? And I don't really understand that comment. In conversations about, will this affect my property values? I was asked for my real estate agent's number so that they could call and chat with her, because her view is not the same as theirs. And then also that they haven't reached out to Tusculum Elementary. If you see on their pictures, they are advertising it on their Facebook page, and there's a donate button right behind it, but yet they haven't reached out to tell Tusculum, hey, we're targeting your kids. Hey, guess what? So when I look at that, I think you're fundraising off children and you haven't let the school know. It's also incorrect data about the building. That data isn't accurate. Tusculum is not as low as they have ranked. Actually, there's 25 schools, including the one he's leaving, that are ranked lower academically than Tusculum. And then it's just also concerning that I am an educator. We have educators in the neighborhood, some that are could do this same type of program. We would not be approved to do this in our own neighborhood because we don't have the religious designation. And so I think this creates a situation where the secular would not, and he has secular components. He has after-school tutoring, he has music lessons. Those things, to me, are secular in nature, and I would not be able to do those despite being highly qualified and trained to do them. So at this time, our neighborhood feels strongly that while this is not personal, because we really desire that this stay a residential property, we would like to see that this be denied at this time. Again, it's not personal. We just really feel that this house in this location should stay residential.
Okay, Shelley Armstrong again, and I'm not going to read everything because a couple more people probably want to speak, but I just want to say, over the last few months, we've told the story about what is happening to our neighborhood many times. We are never met with anything but disbelief, but we have caused people to stop and think about what they'd do if this were done to them, as well as the very possibility that it could. I do not believe it was the intent of this law to bully neighborhoods or to bequeath a power that allows one type of group to do things that would never be afforded to other groups or nonprofits. Special exceptions from the laws everyone else must abide by are not needed, and there is no hardship here. Not one person in the 3 surrounding streets of 49 Aquatic would have bought a home here if this was already in existence. If we wanted to live next to what looks like from the outside and for all intents and purposes a business, we would have bought a home in a commercial or potentially commercial area. The people that have lived here since the inception of Whispering Hills still can't believe it. Maybe that's because when we looked for a home in a purposely T3 suburban area, we weren't looking for what to use in terms of a facility or building, as Mr. McDonald constantly refers to it on his Facebook page, but we were looking for a home. Mr. McDonald says he wants to be a good neighbor, but being a good neighbor doesn't mean using a neighborhood for your own interests and then going home to your own home in your own neighborhood while leaving us to face the fallout and disruption. And regarding the appraisals, those are next to churches, and despite anything Cottage Cove might say, anyone that drives down our street is going to think that that is a daycare.
They are already asking, we have a house for sale, and when they come, we've had people looking at those, they've come over to ask us, what is that sign for, and what is that parking, and it's sitting.
All right, so my name is Michelle Thomas, and I reside at 512 Purnell, which is around the corner from this proposed location. Most of the points there I agree with. I will say that I am a Christian, so that I don't believe that has ever been on the table as far as from the neighborhood's perspective. That's never been a concern. Safety is a big concern. Yes, our immediate neighborhood is walkable, but to get from Tusculum Elementary School to this house location, there is no direct route. There are no sidewalks, except maybe, I guess, if you walk along Nolensville Road, and I'm not even sure that that's solid sidewalk. That's a concern for me. And if you do consider granting this exception, I'm concerned that this organization has already shown some disrespect for the neighbors by expanding that parking area greatly. That was the first thing I saw was, what is all that concrete? And they've already done some things that have kind of disregarded the neighbors' rights. And so I would be concerned what they might do in the future. So, thank you.
Does anybody object to allowing an additional minute for each side so that this gentleman can speak? No objection. All right, sir.
Thank you for allowing that. My name is Daniel Mann, 4913 Aquatic Road, directly across the property, across the street from the property. I just want to echo and affirm all the points that have been made by my other neighbors concerning this. I would like to also add, in addition to that, they do, per their website, make their facilities available to non-program uses. We don't know what kind of parking will be associated with this, or how many people involved, or even who will be doing these. And I would address one other thing in conclusion. Mr. McDonald made an assertion that it was a small group that do this. He made an assertion that it was a small group of neighbors that were opposed to this. In the closest proximity of Aquatic, Purnell, and Millwood, there's approximately 40 homes. Of those, 24 have taken the time to write in or sign petitions opposing this. So I would think that would represent a significant portion of the neighborhood that opposes this action. Thank you.
Any questions for?
I would like to ask one. Have you all been told whether or not parents will be charged for their children to come and be a part of this program?
Our own research is about all I can answer. It appears that the afternoon program is free of charge. The summer program has a nominal fee, and I don't know about their Christmas programs.
Do you know if they're affiliated with any Christian church?
we can't find that they're affiliated. They do receive funds from Christian churches.
Thank you.
Any other questions? All right, thank you very much. The applicant can come back and have, I think, 3 minutes and 45 seconds now.
There was a number of things mentioned. As for affiliation, we are a non-denominational Christian program that is supported by people across many denominations, Christian denominations, both Protestant and Roman Catholic. It was said that we have non-program uses of our facility. I'm not certain what that is, except at our Vine Hill location, we had a church that did use it, but we also had a much larger facility, and that's not in anywhere in the plans for here. And so they did meet in our building at that location. We do not charge for our regular daily program. The nominal fee that was mentioned for the summer program is a field trip fee because we do spend a fair amount of time off-site during the summer.
3 hours a day?
Our summer program, because the Tennessee code that we act under does allow us to run longer in the summer, so we tend to run a longer time, but we spend more time off-site because we're trying to get the kids to have opportunities they wouldn't otherwise have, so we go out to a lot of different locations to do that. And nor do we run that program at all of our locations. We tend to pick one location and do it, and there's a reasonable chance it will not be this location. It's going to be our in-between location because it makes it easier for transport.
And I think the neighbors, to that point, I think the neighbors have brought up several questions that seem to be valid. I mean, the summer program being one of them. And so it seems to me like the answer is you're just not sure yet.
Yeah, we're still working out what we, and like, for example, even some of the things that were brought up regarding, talking to the school, until we say we have a program available, we don't even approach the school. I mean, that's the way it's been as we've gone into other neighborhoods as well. But we work with the school to make sure that any concerns regarding pickup, I mean, we've been doing this for 25 years, so we wouldn't be able to do this if we didn't satisfy all the concerns of the school.
I understand that, and I think sometimes when you have a program and you're proud of your program, and I'm sure you should be, but you see all the positives about it, but the neighbors have some questions that seem to me to be reasonable questions about what your intention is in this residential area in terms of the scope of the program. I mean, if you're going to do it in the summer, if you are going to have a Christmas shopping time, as they call it. I don't know. I've not looked at your website. I'm just trying to facilitate a better discussion about what they might anticipate if your special exception is granted.
Yeah, again, Christmas program, we do offer that right now at our Vine Hill facility because, again, much larger facility. Sure. If we were going to attempt to do the Christmas program, it would not be feasible to do it in this location. We would end up using it or partnering with a church for the purpose of doing it, because you'd have to do it on a large scale. I mean, because of the nature of being in a smaller facility, it's the same reason I wouldn't do it at our Madison location. It's too small a facility. So, I mean, and by the way, we were never asked the question about the Christmas store by anybody at either of the meetings. So that one was just, we try and answer the questions if we do know an answer for them. But sometimes right now we don't know. We don't have a final form of what the program is going to look like. What we do know is what it will look like during the school year. We do know that during the summer, we do have a summer program, but as I say, that is more likely to be operated out of our central location rather than at the Spar South location.
And would it be feasible for you to operate this location only during the school year and not during the summer and use one of your larger facilities for that? Say yes.
Would it be feasible? Not necessarily practical, because I have different reasons why I might have a lab that has computers in this location where I may want to do an activity there. So.
But you could limit your summer program, I would think.
Yeah.
Okay, thank you.
And then I just tried to quickly jot down all the notes that were here. Let me address the parking lot, because I said that we've already expanded the parking lot. If you look at the picture that was taken originally, that's an older picture, while there was still a pool. We repaired that parking lot. The main driveway was concrete. It had asphalt to the right for the parking. We replaced the asphalt with concrete, so it's all one concrete surface, and then put lines on it.
That the neighbors brought up about, because I'm unclear about the program too. Is there an outdoor component to the program? Or are you envisioning that children are going to be receiving education inside the home?
Yeah, and recreation is part of education as well, so to have some time to burn off some energy, but we do that in rotation, so if I have 20 kids, you're never going to see all 20 out on the playground at any given time because some will be in homework, some will be in music, some might be in Bible study. They could be in all these different things in smaller groups, but one of those rotations could be 6 or 8 kids that are out on the playground.
That makes sense to me. Can that be limited to the backyard, and is there a fence?
It is fenced. It's got a privacy fence. We want to actually repair that, and I've started work on that last week because it's not in great shape.
Sure.
And we also, of course, want to extend that privacy fence all the way to the back. It does not go all the way back. So that is our plan for that. And yes, having that in the back, that's easily, because we had no intent to use the front yard for that purpose.
Any other questions at this point?
Okay, thank you.
Anything else to add at this?
Nope.
Okay.
Oh, then I thought you were going to talk some more. I have a question. Could you describe the type of activities you anticipate going on in the house? I understand that you're going to have some recreational activities outside in the backyard, but I don't know a lot about your program as well. Could you talk about what type of activities will happen in the house?
Okay. First and foremost, our program is built around Bible study and teaching Christian principles. So that Bible study is one of the non-optional activities that we have. Most of the rest of our program, homework's another non-optional one. If you have homework, you have to be doing it. That's one of the things that, we've had a great relationship with the schools we've worked with, and they actually let us know if the kids aren't doing their homework, so that we're making sure they're getting their homework done. If we need to assign them tutoring, then that becomes a non-optional. But most everything else in our program is something that they've chosen to sign up for. So whether that's music lessons or whether computer coding, just a wide range of those types of arts, visual arts, there's, painting, wide range of, the list is about 60 activities that they could possibly select from, and it comes down to who we have available for mostly volunteers, because volunteers are the core of what we do. We've got a great city for having a lot of professionals that will come in and work with kids. Okay, thank you.
All right, Councilman, did you have?
Gosh, at the risk of prolonging this, I have been told by, Robert Nash, District 27 Councilman. I've been asked some of the residents understand that the Vine Hill property has been sold, and I was wondering if that was true or not, and whether the programs that are there are conceived to be moved over to Aquatic Way. Is that?
Yeah, if the applicant would come forward so you can be on the mic and.
Yes, we have sold the facility at Vine Hill, and we're actually replacing the Vine Hill facility with 2 other locations, and this being one of the 2. And no, we're not busing the kids down to this location from that. We're serving a new group of kids in this neighborhood.
And then just a couple other things. When you speak of a walking neighborhood, our adults go out and walk our dogs, and again, we're not always out at rush hour. The children that we're talking about coming from Tusculum, if they're walking, if they're escorted, maybe that's safer, but I obviously am not going to support 5- and 6-year-olds walking alone along Whispering Hills primarily, especially when school is getting out. That's when traffic is heaviest. It's kind of adjacent to rush hour when traffic is heaviest. So I still think we need to make sure, and I guess that's part. We have so many questions that aren't answered. I don't think it's unreasonable to ask, how many people do you anticipate to be at this building, and what is the maximum limit? And I think I'd like to see some agreement to that, in that it does affect the traffic and potential safety of people coming and going from this location. As to the comparables that were given to us, I'm not sure that a property on Waits Creek Pike really is comparable to this. This is a totally residential neighborhood. So that's all I say. Yeah. Thank you.
Okay, yeah, that wasn't a question okay, so he answered the questions you had and you presented the issues to us. And I'd like to ask our attorney to give us just a quick reminder, but also for the audience, because there's a couple of comments that many in the letters of opposition, and it was said a couple of times here that there's no hardship, and that oftentimes if you watch this board, we talk about hardships. Those are in variance cases. This is a special exception case, which is a very different set of criteria that doesn't have hardship as a criteria, but it also is a religious organization which falls under federal rules and Tennessee rules, neither of which were passed by the Nashville City Council or this board. We don't pass rules, but
Mr. Chairman, I'd like to ask a question about that.
Well, yeah, that's what I was just going to ask if he.
Well, but I want to enlarge that. I have several nonprofits that work in my community to do all kinds of after-school programs. How can one be assured that a nonprofit is truly under the law that guides us on a church? A church and a nonprofit are quite different, in my opinion. And I just would like to hear a comment about that.
From a land use perspective, Ms. Sanford, it's a matter of the zoning code having to provide for us something under the land use table by which we can categorize the use in question. Here we don't have nonprofit as a defined use. The closest things we can look to are, is it a daycare? Not exactly. Is it a cultural center? Not exactly. Is it a park? Not at all. Is it a religious institution? In the traditional sense of a place of gathering for worship, the explicit traditional notion of a church, it doesn't exactly fit that, but given the other options available to us, and obviously silly examples, it's not an auto repair store, it's not a general retail, it's not a single-family home, that's the closest. So then honing in on your question, how can we be assured, maybe not have been the way you phrased it, that there is in fact a component that makes it a religious institution? It is based upon the representations of the entity making the application for the special exception. You've heard those here today. To be perfectly frank, at a staff level, only when we have been given dire concerns about an insincere expression of religious or spiritual affiliation or belief have we ever really kicked the tires very hard and looked at that, because of the pervasive nature of both the state RFRA law and the federal LUPA laws. So there is at least one prominent example that I can think of in the past 10 years where we just heard stuff that we just didn't believe and did not believe it was genuinely reflective of a spiritual religious belief on the part of the folks who were presenting that information to us. How can we know? We can't. But what do we rely upon? The representations made by the applicants, which you've heard here today.
I forget what the elements are for determining whether something is a church, whether it's an appropriate religious, that part.
The definition of religious institution is really straightforward under our zoning code, at least, and that's what we rely on in terms of figuring out whether or not we think we have a religious institution on our hands here locally. The definition under 1704-060, religious institution means any structure or site used primarily for religious practices. I think that it's fair to assume that the zoning code was written very broadly there by the Metro Council since its adoption in '98 in this current iteration, to use that term religious practices much more broadly than merely a place of religious assembly. There's more language under 1716-170 dealing with the special exception language itself. And let me flip to that real quick just in case it's instructive for the board as a reminder.
Again.
The definition is under 17.04.060.
1704-06.
04060, and they're arranged alphabetically, and that one's under religious institution. Then flipping ahead, as you know, the general provisions for special exceptions apply here, 17.16.150. A lot of times the opponents of any special exception will point to the language under Section C, integrity of adjacent areas, which talks about approval of the permit will not adversely affect other property in the area to the extent that it will impair the reasonable long-term use of those properties. If I can no longer have my single-family residence just down the street, then perhaps this doesn't meet the criteria. Under Section 17.16.170, Part E as in Edward, that's where we get into the special exception particular requirements or conditions for religious institutions. Really, a lot of it talks about parking in that section, more than you might think in that section. They just talk about the parking for either a pre-existing facility used by a or the religious institution for whatever purposes. But again, a lot of this was written with an eye toward places of worship assembly, a traditional church or synagogue or mosque concept. Past that, you do get into a little bit of language for new facilities or new uses, getting into minimum lot sizes, depending on the size of the main assembly area, which again contemplates the auditorium, I suppose. Number of seats will yield number of parking spots. But again, when your primary attendees are school-age children, they're probably not driving. At least, maybe it was one thing if you're doing the pickup and drop-off, which does bear some similarities to daycares, perhaps, or after-school facilities. But again, although it's not a church, you do get those specific requirements under 170, the general requirements under 150, and if the board thinks that they've met those, then it's an appropriate basis by which you could grant a special exception.
But we don't determine necessarily if it's a religious organization?
That is a determination made at the staff level. And is subject to an item A appeal in the event that someone thinks that there is some other land use under which it should be categorized.
And what's the difference, like just a pure after-school, if the mission is, to provide educational opportunities and training in the arts, and then through the power and in the name of Jesus Christ. So the religious, it sounds like that, educational opportunities and training is the primary mission, but with a religious component. And so it makes me think, well, is it, a religious school? And are they governed differently than?
As I explained in the beginning of my answer to Ms. Sanford's question, and I think this is a very similar, though slightly different question, it's a matter of finding the best fit under the land use table. And none of the fits are perfect and exact in this instance, as is often the case. So we wind up having to find the closest thing we can. Here, the alternatives include, but are not limited to, a cultural center. It's not that.
Well, it also includes daycare.
It includes daycare.
I think that's what.
Which has a very specific body of regulations, including state-mandated regulations under the Department of Children's Services. There's testimony in the record today indicating that the state has expressly determined that this program is not under their watch in that regard. I don't know that specifically. I've not reviewed those documents explicitly, but there is testimony to that effect. So, additionally, the question of community education, which conceptually, at least at first blush, sounds like, ooh, maybe that's the winner. When you read the definition of community ed, it specifically talks about the traditional elementary, middle, and high school type education. So that's not this, obviously. Again, just tried to find the best fit. We thought that that was the best fit and still do.
And then can you give us
And I would say, Mr. Michael hit on it a bit in his explanation. So when you're looking at the special exception, you're simply there is no variance. There's not a need to find a variance as it relates to the property. You're looking at the conditions as laid out in the zoning code, the general special exceptions of 1716-150, and then the more specific conditions in 1716-170E under religious institutions. If you find, or if the board finds that they meet those requirements, then you grant the special exception. So exception is a bit of a misnomer, and is that you're not accepting anything, is that if you meet these conditions, you grant the special exception. If you don't find that they meet those requirements that are laid out there, you would not grant the special exceptions. In addition to that, though, if you find that they meet the special exceptions, the code specifically allows for you to place some reasonable conditions on hours of operations, on standards that might relate to the health and safety or welfare of the applicant itself or of the neighborhood. And that's laid out in 176150J under special conditions, as well as under, I believe it's 176150C, integrity of adjacent areas.
Is there anything in, and so, I mean, I guess to me that part of that bottom line is, at least for the audience sake, is that there's not a lot of wiggle room for us, and especially we don't have the ability to say, yeah, this is just the wrong spot for it. If we believe that this is, man, you really shouldn't put a church in a residential neighborhood, because that's my personal belief, that, I mean, I certainly share the neighbor's concern there, but there's not really a path at all, in fact, for us to say, unless it's specifically tied to some extraordinary, government need, and to me, it's like, a non-fenced area on the side of the cliff, but something that's a lot more extraordinary than putting a church in or a religious organization in a neighborhood, that we just really don't have the ability to say, even if we did think that this is the wrong spot, that's not really a criteria for us. And that's what I wanted to make sure that was clear.
Right.
Do we have the ability to?
I was going to say, so I think there's two separate. I think one, you're looking at the requirements as it relates to a special exception specifically, but then a consideration. I believe this is what Chairman Taylor was sort of contemplating, as it relates specifically to religious institutions and the protections that they have under our LUPA and under RFRA. And so RFRA is a little bit more restrictive than our LUPA even, and it states that the government shall not substantially burden a person's or entities' exercise of religion unless it demonstrates that the burden is essential to some compelling government interest, and they've done so by the least restrictive means. And so under RFRA, the burden is on the government to show that they don't meet that the standard has to be met. And so once they identify that this is related to their mission and covered, then the burden shifts to us to show that, to show us how we have not substantially burdened that, what our government interest is, and how we've done that by the least restrictive means.
And I get that. I guess it just seems more like a daycare center to me. And so, and I understand the federal laws and that they're a whole another different layer, but I'm uncomfortable with this special exception being a religious institution when it seems like it does have a religious component. There's no question about it, but it just seems to me like it's daycare, and that obviously entails different requirements, but that seems to be like what it is. And so what I hear is y'all's concern that if you classify it, that you have concerns about liability or problems with the federal law if you don't classify it as a religious institution. Is that? I want to be practical here, but I also don't. I think I don't understand why it's not within our purview to. This is before us to determine that what this really is a daycare center. Because it can't be both. I mean, to me, it's there, where you have certain defined special exceptions, daycare, religious institution, so.
I guess this is an easy way out answer, but it's not before you. It's not publicly noticed. It's not met any notice requirements for the question of definition of the use. That would travel from an appellant as an item A challenge to the zoning staff's determination of the use. And to the question of why can't we, I think that's the number one reason, is it's not before the board. And I know that that's a very technical answer, not getting to the substance of it. Number two, the best path forward there is a creation of a land use that speaks to after-school program, tutorial program, after-school care program, something with a defined scope under the definition section of the zoning code, a line item in our land use table where we could capture something like this, frankly, regardless of whether or not it has a religious or spiritual affiliation.
But isn't that daycare? And I hear what you're saying, but we're asking, our job is to determine whether or not the special exceptions have been met for a religious institution, and if I don't think it's a religious institution, how can I conclude that the special exception requirements have been met? That's what I'm struggling with.
I'm not asking you to like my answer to the question, but here's the answer to the question. Here's the answer to the question, because that determination has been made and is not being made by the board today.
Right.
To the question, how do I read the special exception requirements if I don't think it's been correctly identified under the land use table? You're presented with whether or not, the question of whether or not they meet the conditions for the special exception sought here today. It's being sought as that. So either they do or they do not. Again, the path to challenging the determination of what the land use is, as has come to this board in the past in some instances, is an item A appeal challenging the determination that way.
By the opponents of the application.
By the opponents, sometimes by the people pursuing that particular use at their location. I've hoped that it's been clear that we recognize there's multiple ways to potentially read this. I identified daycare use, cultural center, community education, all things that we looked at and considered. We think this is the best fit for a number of reasons, identified already in the discussion here today. I don't know if you feel like there's more research that needs to be done and that would benefit the board through a deferral. We'll be glad to go back and do more research and provide more information to you.
Well, I guess the only thing, because to me, I agree, it feels like it's a little gray, and I think of other, Room at the Inn and some others that have a pretty strong faith-based component to their mission. Are those the types of organizations that can say, hey, because we were founded on faith and it's a component of our mission, that we can go, anywhere?
Not automatically. And so I just know where you're going with that. Not automatically is the answer. In some instances, perhaps, but if there's a better defined use, such as temporary overnight lodging via Room at the Inn, that's different than the program described here today. And the next program down the street might be providing counseling services. That's got a defined use under the zoning code. The other might be a secondhand shop for people to get inexpensive items for their households, or they're struggling, and that's got a defined use. So again, perhaps, but not automatically.
So you're saying that as a matter of law, the board does not have we don't have the power to determine that it's not a religious institution. That I think that's what you're saying, and I want to understand it, because if that is the law, and I'm going
to bifurcate the question a little bit.
Okay.
I don't hear you saying the board doesn't have the power to determine this is an insincere expression of religious affiliation. Obviously, you can make that call, but I know that's not what's really happening.
I'm not saying it's insincere at all. I'm
just for the clarity.
It's more.
But instead, I disagree with your determination of the land use, Mr. Zoning Administrator.
Correct.
Only if that case is brought to you.
Okay, so. Okay, so that all right. I understand. I think that explains it right. If someone had challenged that, then that would be an item A challenge, is what you're saying, not a special exception. Okay. Thank you. Appreciate that. Yeah. Okay. I appreciate that. Yep.
So we have to.
Microphone.
I mean, right, I'm saying this, so we are solely looking at E, 7016-170E, religious institution, and determining whether those requirements are met, right?
Right. And whether or not special conditions to be, I think the requirements have been met. And I think planning has it right. To me, it's boiling down to what the council person has expressed, and neighbors have expressed concerns that I think warrant a discussion of special conditions.
I agree. Where are we procedurally?
We've closed the public hearing, and we're asking.
Are we discussing?
Yes.
Are we in agreement that the requirements have been met for a special exception?
Assuming that that kind of catch-all of impact is not applicable, and I think that the RLUPA and the RFRA would override that based on what?
I think if we have to take the Mr. Michael's assessment that we're not here to talk about whether this is a religious organization. That takes that off the table, and then it makes it look differently. But I'm very gravely concerned about this many neighbors coming here to tell us how unhappy they are with this. And I don't hear the council member being that excited about it either. So that's where I was troubled and still am.
Well, and I guess to me, the only other thing, and I know folks have been here for a long, long time, but, to me, I don't know that we have a whole lot of space on the religious piece of it, because I think that is something that potentially could be challenged, to say that, hey, that there was an error in the classification, but that's not before us today. I understand that.
Right.
And I do think that there are reasonable criteria or conditions for this that we've talked about. But the only outstanding thing, and again, I understand the neighbor's frustration, because we got a little bit of this from the applicant too, the vagueness in terms of just what is the scope of this. And to me, that there's some of that plays into, the transportation plan. If you've got 50 kids, then how do they get there? And, if you have 100 kids, and I know that he's absolutely limited by the fire marshal's determination of occupancy, but, if that's the public safety, legitimate public safety concern, which I think it may be, do we need additional information from the applicant? Is it fair enough to ask for that to be defined in a more specific way, so that that plan at least is out there as part of this proposal? That to me is the key. But and the only question I had for legal was that the council member had asked that that the religious use was and I may be paraphrasing, so I apologize because I know he's still here, but said something that the religious use was specifically an after-school and summer program for youth, a faith-based, say, after-school and summer program for youth, and if the scope of that changes, then the board would require, he'd ask that the board put a condition that the applicant reapply. And is that a fair condition? Are we allowed to put that type of condition on a religious use property to say, if all of a sudden you want to have worship services for 200 people, we've said you can have a religious use, but if it changes really more from what you said here, then you need to come in and apply to go through the steps again to say that there are no compelling government or reasons that you shouldn't do this.
So I guess your question is, are you saying that you would otherwise not approve this as a special exception, that you're only approving it because it's a religious institution, and then if a portion of that somehow changes, you would put a condition on them to come back?
Or a religious institution for a specific purpose. I mean, once we say, I'm just, that's the councilman, they'd ask that in the letter to say, hey, if the scope of this changes, can we make them reapply?
Well, I guess when you say that when the scope of it changes, you're saying if the scope of it is no longer that it's a special exception under 1760.
I'm saying that it's no longer a religious-based after-school program and summer program for kids. If all of a sudden, it was. Well, I guess I'm saying
How about this, Mr. Chairman? I think that you could potentially place that condition that if there was a change in the scope or nature of the program, because it might be something that merited some safety-oriented conditions from the Board of Zoning Appeals, conditions which can be applied on special exception cases, as identified in 1716 as well as under 1740-270. So If there was a change, that change, because of some performance field thing, traffic coming in or out, might be some basis by which you need a condition. Certainly, it would be appropriate to say if there is a change, it would need to come back for a new special exception. Doesn't mean it would be guaranteed approval or guaranteed denial. It would have the same legal criteria to be evaluated, but because of those changes, you might need something different. Therefore, it would be a not unreasonable condition to pin, and I don't know of any case law offhand that suggests that a condition along those lines is a restriction on the use. After all, a condition necessarily suggests approval of the special exception, which ultimately demonstrates compliance with those laws.
I also would point out that the Section J of the special exception section of Title 17, it's a lot of zins to say, it contemplates establishing permit expiration date. And so although this isn't a date certain, if it expires upon a substantial change in the use,
So what?
then I think that's contemplated as an expiration. If the use changes and it's no longer what they've presented today, then they have to come before you. Now, they may still have their religious mission, and they may still come before you, as a religious institute with a different kind of religious institute use, different from what they're doing today. So I think you could say it expires upon a change in this specific use that was outlined today.
So, well, we could also put a special condition on the number of children that could be there. And to me, it's going to be really hard to police has the use changed or not. And I think what the neighbor's concern is the traffic and the number of people there. And to me, that kind of ties in with limiting the number of children that are there. And I think the councilman has asked for, he believes 15 is the max. And I guess part of my struggle with this is I think that if it were a daycare center, I'm assuming that there would be more definite rules about, well, here's how many children you can have. And so because it's defined as a religious institution, we're kind of left. So, to me, I think with the level of opposition and the councilman believing that 15 is reasonable, then my thought is that is at least one special condition that I would want to put on it. And I do believe the special exceptions for a religious institution have been met.
I agree. I do sort of think, and I mean, I don't know. I don't know where the number 15 came from. Just in listening to the applicant, he seemed to think that number was low based on their number of volunteers they would have. I'm fine with setting a limit. I would be willing to go higher than 15 if that's something we can discuss.
I really, if we can get there without hearing it again, I'd be happy. But I also I'm not sure how we get to that number without some participation of the applicant and the councilman. And so that's, and there may be a way to, pass some conditions, but leave the traffic and transportation plan and the limit of the number of kids, just those two items, to be determined at a future meeting to give a specific proposal there. I guess I'm okay with, I think both are reasonable, and I think both have government interest, compelling government interest in regard to safety, given the lack of given this infrastructure that's there and the testimony that we have had. I think that it's worth exploring that more to make sure, and again, not unreasonably, not 2 years from now deferral, but next meeting or the meeting after that to get to that piece. But if you have a thought to get to those two items sooner, then that's okay too.
What about the idea of determining today that the conditions for special exception have been met, giving the applicant and the councilman the opportunity to see if they can agree upon conditions to be placed upon the use? I can give several examples that are in my mind, letting them report back to us, and what we would be then determining is simply the conditions to be placed on the use, not whether or not the requirement for special exception has been met. I feel like that gives the neighbors some weigh in.
I think that's a good idea. I would support that.
I know we've spent a long time hearing it. What do y'all think?
I would support that motion in light of just the residential character of this area and how this proposed use might impact that. I think that that's a good path to take.
That's kind of my thought. What do you think?
I'm still struggling with hearing both council member and Mr. McDonald say that parking, and by the way, I travel this street often. I have a relative who lives very close. And so I'm very aware of how much traffic there is in the areas and then the streets that don't have a lot of traffic. But I heard the council member early today say that there were no parking signs, but people still park there. Well, then I heard Mr. McDonald say that. That doesn't make it right, even though they do break the law. That's not something we should encourage. And I'm very worried about parking because, and the congestion it's going to cause. I can imagine me trying to get down through there and not being able to get through there because of cars lined up.
All right, how about, can I try something? That we approve the special exception because the conditions have been met for the religious organization, and we offer the following conditions. That they comply with the parking, metro parking requirements for a religious organization, that there is no on-street parking, that there is limited signage, that the applicant had agreed to the garage face and that it not be internally lit, that the activities for the children are limited to the backyard, outside activities limited to the backyard, which the applicant had agreed to, that the religious use for this property is specifically a religious-based after-school summer, a religious-based after-school and summer program for kids. And if this scope changes, then the applicant would be required to reapply to make sure that the board agrees that it continues to satisfy use as a religious entity, and that the maximum number of children be limited to 15 until the applicant, and I'll say within the next, and y'all listen to me and tell me if I mess this up, but until the applicant and the council member shall meet and develop a proposal for the number of children. They may not agree, but that we give the applicant the opportunity to adjust that number either the next meeting or the meeting after that.
I could support that. I think the 15 would be 15 per day during any 24-hour cycle. Is that?
I would say 15 at
any given time.
At any given time.
Okay. That makes more sense.
And again, with the expectation that the applicant will, because the applicant has said, I need to have more kids than that, but the applicant has not given us any indication that there's a true sense of scope. Right. And that rule, or that condition, that the applicant will be allowed over the next 2 months to come back to us with a proposal that's based on additional conversations with the council and or planning, not the planning department, but his own planning and business planning for this operation. And that the applicant also, let's see, we addressed the traffic, and that the applicant that part of that plan for getting that expected number of children to be a traffic plan that helps describe how those children will get from school to the facility in a safe manner. That what we expect is come back, tell us how many people you think you should have and how they're going to get there safely, and then we can determine that maximum number. Till then, it's 15 at any given time. Does that?
I would second that.
Are there, and then I'll ask.
Do you want to include a date certain when they're coming back to you, or?
Well, I mean, I guess the question is, normally you'd ask to say, hey, do you want to come back next meeting or the meeting after that? And that's fine, but if it takes a little longer, maybe that's it. I'll ask the applicant and the council member if 2 weeks to, you can meet the first meeting in December or the second meeting in December.
How long is it going to take you to kind of determine what you're going to do? I mean, it's really, the scope issue is really the problem here. We don't know how many kids and how many people you're going to have working.
All right, so
if we could get some idea of that, then we can sit down and talk. How long is it going to take to get there?
So we can say the next meeting is the first Thursday of December, but maybe the second or the third Thursday in December, the second meeting of December would be more appropriate. That'd be approximately a month. Again, then Thanksgiving and other holidays, that'd give you a little bit more time.
That's December 19th.
All right, so I will say that question will be deferred until the second meeting of December. The other conditions are part of my motion, and so we will hear this again if this motion passes at the second meeting of December. If for whatever reason the two of you agree that you need to have an additional time, then I would be willing to accept a deferral at that point to a time that makes sense for both of you.
What is that date?
The 19th of December.
Is there any other, and I'm going to ask, I made the motion, did you second?
I seconded it.
And the motion was seconded, and I'll ask our legal help if there was anything of the motion that seemed improper or askew with.
I'm sorry, I didn't hear the question.
Oh, I just asked if that motion, or that would be in.
I defer to Metro Legal, but I did not hear anything that struck me as improper or illegal.
Or that would run afoul of the Religious Freedom Acts that we were talking about. All right. So
Go ahead, make your motion.
it was, and it was seconded.
Okay. So I support your motion, but I wanted to offer an amendment, and if it doesn't have any support, then we can move on. Because of all of the talk about like a daycare center and sort of how this sort of feels like that, I'm wondering if we should look to the code in section 1716-160 about sort of the class, like the numbers that they sort of give a range for a house for a daycare, and it's 13 to 25 individuals. I know the councilman offered 15, but maybe we offer 13 to 25 until they come back, just so that, because I don't know what 15 is based on,
Yeah,
other than the councilman
I'll accept
offering
that.
I agree.
13 to 25 as individuals per the concern that it appears to be more daycare-like.
That's the daycare reg.
Yeah.
Yeah, it's code, it's 17.16.160, section C, and then
Do you have
subsection 1.
That's, okay.
So that was been accepted by the,
Okay.
so yeah, and that gives it a lot, like, I like that it has more teeth, because I think everybody's trying to figure out, well, how do you determine something without more information, which we don't have, which hopefully we'll have in a month. So we have a motion, we have a second. Is there any more discussion? All in favor, say aye. Any opposed? That motion passes. Next case.
Next case, 2019-487, involving property at 2818C West Kirkwood Avenue. This is a request for a variance from sidewalk requirements to construct 2 single-family residences with a reduced contribution to the in lieu fund. Before you is the zoning map showing the zoning of the property is R8. Aerial photography giving you a sense of the surrounding area. Members of the public, if you could please go outside for your conversation so the board can continue to proceed with their cases. Thank you. This is a site plan submitted by the applicant.
And then finally, the photograph showing you the current conditions of the property. Is there anyone here in opposition to case 487? Seeing none, Mr. Cuthbertson, you'll have 5 minutes.
Mr. Chairman, members of the board, Dwayne Cuthbertson, 1806 Allison Place. I'll be pretty brief with this one. This is a site where 2 homes have recently been constructed. The plans were permitted with a sidewalk shown on West Kirkwood. They had every intentions of building them, but through the construction process, they had conversations with the Public Works inspector and then also stormwater inspectors. And those conversations led to an informal request on their part for us to pay the fee in lieu instead of building them. The issue for them is related to topography. The northern side of this sidewalk, where it terminates adjacent to the next property, is going to have about a 12 to 18-inch drop from the edge of our sidewalk to their property. And so the Public Works inspector, they don't want to, they see that as a potential hazard, and they would rather us not build that sidewalk. Stormwater, there's enough flow toward our property to warrant concern, but not enough to kick us into a grading permit, so the plans were approved by Stormwater, but Stormwater still has concerns about water sloping toward our curb and gutter that we'd build here and falling north and then falling into the adjacent property. So again, they've asked us to pay the fee in lieu. The owners of the property are somewhat agreeable to paying the fee in lieu, but their argument is they are going to build and have built a 16-foot wide driveway leading into this property. So the frontage is 60 feet wide. The fee in lieu would be applied to that frontage. 60 times 152 is what the code would require them to pay. They're asking the BZA if they can pay an adjusted fee in lieu, accounting for that 16-foot driveway. So they would ask to pay the fee in lieu on 44 feet of the driveway that they would have, or sorry, the sidewalk that they would have otherwise constructed.
And then, did you get anything, I mean, I guess Public Works, because planning, it says basically build a sidewalk or build an alternative design.
Sure.
And, but I guess, you know, when we were talking about it, prior, it just sounded like Public Works, that it's possible to build a sidewalk.
Sure. Absolutely, it's possible to build a sidewalk. And my clients, truthfully, they'd prefer to build the sidewalks. It'll be cheaper for them to build them. And yeah, if you call Ben York or any of those reviewers over at Public Works, they'll say we can build the sidewalks, and that's true. We can. It's the field inspectors that have really identified some of their concerns and asked us to approach it.
And so your request is just to pay the in lieu, but to not have to pay the 16 feet of driveway that you've already done?
That, correct. Yes, sir.
Okay.
And so why not work with, planning recommends, coordinate with Metro Public Works about an alternative sidewalk design? Why not do that? I mean, it can be built as you're concerned that it's just going to be prohibitively too expensive.
I think my clients would say they're not responsible for improvements off-site. So they could build the sidewalk, and I suspect that they could build some sort of ramp on the other side, but it's outside the scope, outside the limits of their property.
Or grade, they wouldn't grade down to get to that?
Well, and then there's a driveway, I didn't measure it, but it's pretty close to the property line, so can they grade sufficiently within that space? I don't know the answer to that.
Well, but so where I'm hung up is they're recommending that you work to try to find an alternative sidewalk design, and I hear what you're saying is you've just kind of concluded that's not going to be feasible, and you'd rather pay the fee in lieu, and so, but why not dialogue with them to see if you can come up with an alternative sidewalk design?
Well, I mean, that's possible, and with regards to stormwater,
And if it's not, you can come back and tell us it's not possible.
well,
Right.
Another part of the story is both of these homes are sold. And so they need to final out their UNOs. So they either need to build the sidewalk pretty quickly and get everybody to inspect it and sign off on the UNO so that they can actually close, or they need to pay this fee and go on down the road. So a delay of 2 weeks or 3 weeks, not something I suspect the buyers of these homes are going to be happy about.
But that's, I mean.
That's not your problem.
That to me is just not, I mean, that, I know how things go in life and you don't plan for stuff and I get it, but that's just not a hardship. And how long do you think it would take to sit down with them and try to figure out whether you could come up with an alternative design? And
just based on,
and there's no way they can close without this resolved? I mean,
they got a conditional UNO on the back unit because the front unit hasn't been finalized out. So I don't think a lender is going to let their buyer close without the UNO.
And you can't get the UNO without resolving this
without the sidewalk being taken care of one way or the other. Yeah.
John Michael's affirming that. So, well, and the other thing is, it looks like some neighbors are pretty much of the opinion that the area would benefit by sidewalks, because apparently there are some over there now, and so
I've talked to a handful of those who are interested, because my name and number is attached to the application, and I think many of them assume that when we make these requests, they just assume that we're saying, nope, we don't want to build them, we don't want to pay, we don't want to contribute to the network in any way, and in most cases, that's not the intent of our requests.
How much frontage is there?
60 feet.
So 60 less 16 is what you would be paying?
44 that's what we're requesting.
Any other questions?
I thought there had been a reduction in the linear foot fee. Where did I get that idea?
There is not by the language of the law. That's what they're asking for, is to reduce it by the feet of the linear feet of the driveway. But that's what the variance they're asking for. That's not what the law. The law contemplates the whole frontage.
When he quoted a figure, how much per foot, then I thought that number had been reduced. And
I think the number has actually changed from about 152 to about 182. That number is determined by Public Works on an annual basis, and they recently changed it. I believe it was increased.
Oh, I had heard it was decreased. Sorry. Thank you.
I wasn't aware of that either.
Isn't there a cap on what the applicant would pay?
There is a cap. It's 3% of the cost of construction.
Which we've got two pretty decent-sized homes here. I think, I didn't do the math, but I think 3% is a decent amount.
Any other questions? All right, we'll close the public hearing. Thoughts?
Well, I think from a public policy standpoint, the idea of this law was to put in sidewalks and where you can't, or where you have the option, pay the in lieu of fee. And I don't, the fact that the applicant's willing to pay the in lieu of fee is less than 16 feet it's going to contribute to the purpose. So, I think I'd probably be okay with that.
I can support that.
Make it a motion.
I'll make that a motion that if the applicant will pay the in lieu of fee for the frontage less the 16 feet that's the driveway, that we grant the variance.
I second.
Got a motion, have a second. Any discussion? All in favor, say aye. Aye. Any opposed? Motion passes. Next case.
Next case, 2019-488, involving a property at 1108 Paris Avenue. This is a request for a variance for minimum lot size requirements to construct a detached accessory dwelling unit. Zoning map before you, showing the zoning of the map is R8. Area photography giving you a sense of the surrounding area. Site plan submitted by the applicant is before you now, and finally, the photograph showing you the current conditions of the property. Seeing no opposition here for this case, Mr. Cuthbertson, you'll have 5 minutes.
Thank you, Mr. Chairman, members of the board. Dwayne Cuthbertson, 1806 Allison Place. I'm here on behalf of the homeowners of 1108 Paris Avenue, and they're asking for the lot variance in order to allow a detached accessory dwelling unit, a DADU. Just to be clear, it's not a request to allow 2 principal dwellings or 2 homes on the property. They want to keep their existing home, and they have every intent to build a detached garage with space above it. They're asking for this variance so that they can use the space above it as an accessory dwelling. This property is located in the 12 South neighborhood, and it's also in the Waverly Belmont Historic District, which has standards that apply to a detached accessory dwelling, and they have every intent in going through that process with Historic and constructing something that complies with their standards. This property, I feel like, is fairly unique in that the variance requested is very minimal, and this is a pretty old neighborhood that contains a variety of housing types. Many of the lots surrounding this subject property contain 2 dwellings. A lot of them also have detached accessory dwellings, even though they have similar lot sizes, either the same lot size or a lot size perceptively similar to this one. In fact, on this street, there are single-family homes that have detached accessory dwellings behind them on perceptively similar lots. Again, we're not asking to do anything that we feel is out of character with this neighborhood. The structure that we're asking to build can be built by code. The request is really just related to the use. It's an older in-town neighborhood. It's a location that can handle this incremental density that we're requesting. It's in a neighborhood that is becoming, or is, but becoming even more unaffordable to folks, and the housing that we're requesting would add a smaller unit that would be relatively affordable and allow others to participate in this active and desirable neighborhood. So with this request, we do have the support of the council member. We have support from surrounding neighbors. We've sent out 263 notices in a neighborhood that's very active when it comes to land use matters, and we have nothing but support. So with that, I will stand for questions.
Any questions? All right, no questions. So anything else to add?
No, sir.
All right, we'll close the public hearing. This seems to be pretty similar to the case that we heard earlier today. It's about 6% off, and strictly for a day-do. There's a nice chart that was provided that showed not every house by any stretch in the neighborhood eligible, but certainly 60, 70%, and the number on the street. So I don't.
I was just going to say, and I don't know if it's a difference that matters. I guess the only difference is that the other case was converting an existing garage, and it sounds like, and correct me if I'm wrong, are you guys building a new unit, or are you going to just convert the existing garage?
No, there's no garage behind this house now. They're going to build something, they're going to build a garage in space above that complies with Historic. They just want to be able to use that space above legally for accessory dwelling.
Thank you.
Okay. So I guess it does have to go through the full design review for Metro Historic and meet all of their setback requirements, and I think they have some pretty new and strict concepts of how day-dos have to operate in that neighborhood. I guess all neighborhoods, but I know they have a new day-do plan that presumably they would have to follow as a historic neighborhood. So I don't know, does that alleviate concern, or is there?
Yeah, it does, actually, but I think it's an important difference.
No, I do too, yeah, between that and the other. Well, and then you try to compare, and like I said, even with the fence and everything else, with like, how does it compare to something else we heard, and they all are just a little different sometimes, right? So that's true. So.
I'll support your motion.
Oh, okay, I couldn't, honestly, it's been so long, I couldn't remember. It's like, did I make a motion or not make a motion? I'll move that, that we approve the variance with the condition that it only be applied to a detached accessory dwelling unit as a second unit, and with the assumption that it will go through Metro Historic and comply with all of those regulations.
A second.
Have a motion, have a second. Any other discussion? All in favor, say aye. Any opposition? Nope. Good luck. Thanks.
Moving on to the short-term rental cases on the docket. The first one the board will hear is case 2019-464 involving property at 7279 Santila Way. This is a challenge of a denial of a permit due to operation before obtaining a permit. There's no one here in opposition to this case. Mr. McBroom will make the presentation on behalf of staff, and then the appellant will have 5 minutes to make their presentation. And just in case anyone ever doubts how committed Mr. McBroom is to the Codes Department and this board, today is his birthday, and he is at the meeting on his birthday.
Well, happy birthday.
Thank you. Good afternoon, Board. The operation dates were March of 2019 through August 19th of 2019. Number of rentals were 44. Previously was not permitted. 8/4/19 host letter was sent to the previous owner who received the host letter and called. She indicated that she had sold the property on December the 7th of 2018, which had not been recorded at the time the letter was sent. Therefore, I sent a notice of violation to the new and current owner, Justin Jacobs and Ms. Barsgar, who I believe is present today, and I received a call on, that letter was sent on August the 13th. I received a call from the appellant on August the 22nd, and I told her how to comply by the September 3rd reinspection date. I gave her information to contact Airbnb to have the advertisements removed and cancel the bookings, and then how to file an appeal with the Board of Zoning Appeals. On the reinspection date of September the 3rd, she came to the office and asked if there was anything else that could be done to avoid the ceasing of operation, and I reiterated the fact that the ordinance would not allow that. I told her that she would need to cancel her bookings and have the advertisement removed, and she would need to do so quickly and to contact me when that had been accomplished. She called me early the next morning and told me that bookings had been canceled and advertisement removed, which I confirmed. The advertisement has not been reposted. And on that same day, she she filed her appeal for the Board of Zoning Appeals, which was September the 4th. There were no complaints, no registered complaints associated with this property, and no other action has been taken.
All right. If you would state your name and tell us why you're here. Name and address, tell us why you're here.
Yes, happy birthday. My name is Zaina Barzigar, and it's about the property on 7279 Santila Way. We was not aware of the permit requirement that we needed to take in our HOA or the selling of the property. All the paperwork that I have here, we didn't see anything, and so we do plead guilty for operating out of ignorance, and I am here to see if I could get that permit possibly.
And is this your home?
Yes, it's our residence.
Okay. Are there any questions? And after you went in to say, hey, I need my permit, you were given instructions, it looks like about 10, 15 days later, you hadn't quite done that, but then the next day you took everything down, and did you cancel any of your listings?
Yes.
Would you just call Airbnb and say you need to cancel those because they don't have a...
My fiance did all of that. I'm not sure how exactly, but the advertisement is down and the bookings were canceled. I just had a baby at that time, so I'm not aware of most of this stuff.
Okay, good. Well, congratulations on that.
Thank you.
So All right, are there any other questions?
Have you talked to any of your neighbors about your
Yes.
permit? I know that there's some letters in the file, and I'm just wondering if you had had the chance to talk to any of them.
Since we were operating without the permit, and I told them what was going on, and they said, we didn't even realize that was happening because it's not like so many cars. On our advertisement, we allowed only one car, and it was a certain part of the driveway. And the rules of the place is pretty strict, no partying, no alcohol, no nothing. If anything that is out of ordinary, we tell them, hey, we can't host, we'll have to cancel you. They just didn't, they were indifferent more so than anything. Yeah.
Any other questions? All right. Did you have anything else to ask Dad?
No, I had to go back with the property taxes and stuff. It just hasn't been a year for us to even, and we haven't operated that long to even do that. So this year in the taxes, we'll be having that taken care of.
Okay. All right, thank you. We'll close the public hearing. Thoughts?
No thoughts or no questions, I guess. I guess I'll try to make a motion. Since I was the very late one to get here today, I'll do my part. So this is like most cases we see where the applicant made a mistake and they canceled all the bookings. And so I don't think the penalties should be as severe as 1 year. So I will move that the zoning administrator did not err, and that the applicant be able to apply for a permit on, let's see, 3 months from the date of the filing, and I don't know what the date of the filing was. It was September 4th, so 3 months from September 4th.
I would second that motion.
Have a motion, have a second. Any discussion? All in favor, say aye. Any opposed? All right, you're eligible to apply for a permit on December 4th. Don't rent or do anything until you get a permit, but you are able to apply for a permit on that date.
Okay, thank you very much.
Next case, last case.
Last case for the board's consideration is case 2019-477 involving property at 1015 Mansfield Street. This is an item A appeal challenging the denial of a permit due to operation after expiration. Mr. McBroom is here, will make the presentation on behalf of staff, and then the appellant will have 5 minutes.
As expressed, this was a previously permitted short-term rental property. Owner-occupied permit issued on December 22nd of 2017, subsequently expired on December 22nd of 2018. On January the 11th of 2019, the host letter was sent. Estimated delivery would be January the 18th. Operation dates were February of 2018 through July of 2019. Number of rentals were 105 total, 44 after the permit expiration. On July the 1st of 2019, Mr. Hoyles emailed the zoning examiner, David Frabbit, asking about renewal of the permit. Mr. Frabbit responded that the permit had been expired for 7 months and that the advertisement and operation had continued during that time. Therefore, renewal would be denied. If he wanted to obtain a permit in less than 1 year, he would have to appeal to the Board of Zoning Appeals, and that Mr. Frabbit would assist him in the paperwork. The advertisement was removed on or about August the 6th of 2019. The appeal was filed on September the 26th. We received no documented complaints, and there were no other actions taken.
And do you have any evidence of any rental activity after the advertisement was removed?
No, sir, I do not. We had 3 in July, but given the time frame, that's not out of the ordinary, but nothing following that. And also, once the advertisement is removed, it's very rare that we would have another document stay because they cannot post a review at that point.
Right.
But all indications are once they realized their situation, they tried to come into compliance.
All right, if you would, state your name and address and tell us why you're here.
Faith Salmon, 1015 Mansfield Street, Nashville. I am here to hopefully get my short-term rental permit back as soon as possible. I was talking to a friend on August 5, and who's also a fellow host, about how they just renewed their permit and talking about the increase in permit fee. And that's when I sort of realised that there was a problem and that I hadn't renewed my permit in the prescribed time. And so that's when he mentioned that I took it down, listings remained down, and I haven't had any new bookings since that time. And I didn't receive that violation letter on on January 10 in the mail for whatever reason. Otherwise, I would have happily taken action back then instead of now. So this permit expiration is a genuine mistake. There's no malintent behind it. I originally took the proper processes up front to get the permit. I just forgot to renew it. With Matthew Hoyle's emailing, which I didn't think about, I think there was just so much confusion as what to do, because this is a primary residence. I work for myself. This income is like significant to me, and I just didn't know like which way to turn about it. And I guess that's all I have to say.
What was the last day you rented the property?
When I took it down early August.
And then you didn't rent after that?
No.
And did you cancel bookings or anything like that? Or?
There was a booking in the calendar for like that August 5th date, which was a one-night stay.
And the day after you took it down and you didn't rent after that?
Yes.
Okay. Any questions? Anything else to add? All right, we'll close the public hearing.
Sure. I will make a motion that the zoning administrator did not err, and that the applicant, because they removed their advertisement after they realized the mistake, that a penalty of less than 1 year should be applied, and I will move that it will be a 2-month penalty from the day of application, which was, again, I don't remember. I think it was September 26th.
No, it was August 26th. Did you say 3 months?
I said 2 months. What I have on the one here from Metro is September 26th, so that would put it at November 26th.
Was it 3 months before?
It was 3 months, but they didn't have a permit. She had a permit and it expired and she forgot to renew it. Yeah.
I'll support that.
Is that a second?
I'll second.
Have a motion, have a second. Any discussion? All in favor, say aye. Anybody opposed? All right, so you can apply for a permit, I think, on the 26th of November, or the Monday following, I don't know what day that is, but the first business day after the 26th of November. Don't rent, don't list, don't do anything till you get a permit. Thank you. We're adjourned.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.org.